It's also worked on the writing about all the source. That matter. Without notice, without formal notice, they have blacklisted us.
Yes, who is for the other side?
I monitoring for the state or.
Milord, notice was issued to them, Milord. Actually, on the last occasion, it was noted by the office that neither AD nor repudiate return.
What?
Neither AD.
Not AD, Ajay. Yeah.
And not neither AD nor council office return. Milord, she directed me to take instruction from the department, Milord. And Department of Skill Development and Technical Education informed to the opposite party. They have sent a parabolic summons, Milord.
Ooh. Sir, only question is that whether it was served on them or not. Mere issuance of the notice is not enough. It has to be served. Show us the proof of service.
Are they admitting that they have been served with the notice? No.
They'll send a
No, have you taken that instruction, specific instruction? That whether they have received these notices issued from this registry?
No, they are not assessed.
Not received. That was important. That was
That was there, and you are blacklisting a person. At least he has a right to be heard before the blacklisting.
No, already
Right
this
from
court-
that the judgment. I think in the last one is a Panda infrastructure.
Panda infrastructure and this court in division bench, he has enclosed, he has referred to that document.
Arthotran PM.
Yeah.
2024 ILR. Chandan case is very clear. This court devised that principle. Without hearing, you cannot blacklist him. Audio alternate pattern is the basic tenet of that. So,
Now, then they will file an affidavit.
The Supreme Court, I think erosion judgment is also one of the very important one. It says is akin to a civil death. Can you do it without hearing? So
But she was referred to that erosion judgment in Arthotran PM case.
whatever. I'm just refreshing my memory. I have delivered a judgment. We have delivered a judgment.
and we have struck down that day that any ever
That whatever we have also defined. Very interesting word which is used.
But she will file an affidavit in this.
What affidavit?
now what is the instruction on that?
Instruction is that you have not served.
No. Have they is this World Skill Center? No, please tell us whether they have afforded any opportunity of hearing before blacklisting or not. That is the only.
That he has been very fair in his submissions. Very fair.
Of course, on instructions.
Well,
Don't put him in an embarrassing situation.
on instruction.
You are extracting something from his mouth.
He said no.
He's keeping mum, but you are really extracting the words from him, from his
He
mouth.
said no, and it was not my intention to put you in any difficulty, Maharaj.
It will be better we file an affidavit.
Why? Give him an affidavit. What can be done? Just affidavit by 2 days.
And take specific instruction. These notices are served on 2, 3, 4 or not.
Counter affidavit by Friday. No, sorry. Today is a Monday, no?
Monday.
Counter affidavit by Thursday. Matter to appear on Friday.
6th February.
They should retain its position. Same positions. Great system.
Item 2.
I hope that it will be concluded today.
Look, before last.
I'm sorry.
Not even before.
I'm sorry that day itself it would have been concluded for my indisposition, I think.
No, I'm grateful you are
On Friday.
taking me more than once, but. Thank you.
Where is Mr. Singh? He mentioned the matter. Actually, there is one matter.
Briefly, Lord, I'll be crisp and non-repetitive, Lord, as far as possible, and adopt, Lord, whatever has been said already by the preceding councils. I will not dispute that Article 39B makes it clear that material resources of the community have to be utilized for the common good. Nobody can dispute that. I also do not dispute, Lord, that minerals, where the minerals are found in state land and they belong to the state, that, Lord, is a matter of exclusive privilege. The MADA case, 9 judges judgment holds so. So it is their exclusive privilege and it is regulated by the MMDRA Act. They can choose whatever method they want for granting, as long as, Lord, it is just reasonable and fair according to Article 4. Now, if you Lordship will recollect, Lord, the first point which I had argued was that in view of Section 10 capital B, which the respondents have not answered, in view of 10 capital B, it is the lease which is put up for auction. And 10B requires that you will set out all the bidding parameters and what share of the revenue the state wants to recover from us. Everything has to be set out in the tender notice, and which is then followed by MDPA and the lease. Now, that being so, the lease in my case was executed in July, 2nd July 2020, which is much before 1A, 1B, 1C, and the proviso to 12A had come. So these are subsequent changes. My submission was that in view of Section 10B, everything must crystallize in the auction. After the auction is concluded, then the financial rights and liabilities of the two parties, the state on the one side, and gets crystallized, and that cannot be changed. You may change whatever other procedural kind of rules that always, Lord, the Lordships have held procedures, amendments which are procedural apply, Lord, retrospectively also. But if they are touching and impinging upon vested rights, accrued rights, then, Lord, it cannot be retrospective. The only method of altering them is that the legislature or the parliament in this case must pass a law and alter the terms of the contract, which also your Lordship will then examine retrospectivity being given is just fair or not. Now, that being so, if your Lordship looks at 10B once again, because they have not answered at all, either the learned Attorney General nor the Advocate General have referred to this. And I had referred to Vatika and all that to Shobler, which has not been responded. Kindly have from 10B3. Or before that, not just, I'm sorry, kindly have 8A4 also. In view of 8A4 and 10B, kindly have 8A4 first. On the expiry of lease period, the Lordship got this one? 8A4. Section 8, capital A, subsection 4
of the appendix.
of the MMDR Act. Section 8, capital A, bracket 4, subsection 4. On the expiry of the lease period, the lease shall be put up for auction. You mark this expression. So the lease itself is put up for auction.
Yes.
As per the procedure specified in the Act, not by rules. Now, kindly look at this section 10B now. Specifically made in 2015 only because 8A4 was there, which is 10 capital B. And please have subsection 3. in areas, I'll also got this. In areas where the existence of mineral contents of any notified mineral is established in the manner prescribed by the central government, the state government shall notify such areas for grant of mining lease for such notified mineral, the terms and conditions subject to which mining leases shall be granted, and any other relevant conditions in such manner as may be prescribed by them. So everything has been to be notified, the terms and conditions subject to which you want to grant a lease. It's your wish. Keep the public interest in mind. It's your exclusive privilege. Prescribe your terms and conditions, but then include it in the tender notice so that the bidders know what liability I am going to incur and how I am going to operate this. Then kindly have subsection 4. For the purpose of granting a mining lease in respect of any notified mineral in such notified area, the state government shall select through auction by method of competitive bidding, including e-auction, an applicant who fulfills the eligibility conditions. Now, leaving the rest, well, let's kindly come to 5, which is the most important. The central government shall prescribe the terms and conditions and procedure subject to which the auction shall be conducted, including the bidding parameters for the selection, which may include a share in the production of the mineral or any payment linked to the royalty payable or any other relevant parameter or any combination or modification of them. So how you want to protect your interests, you have to spell it out in the tender notice. Do you want to have a share of the mineral which I am going to mine? Or do you want to have royalty or some other basis in addition to the royalty under Section 9? Whatever, it's your discretion. So exercise it, let the bidders know, let them compete, and then rules. Now then, kindly have 6. Without prejudice to the generality of 5. The central government shall, if it is of the opinion that it is necessary and expedient to do so, prescribe terms and conditions, procedure and bidding parameters respect of category of minerals, size and area of mineral deposits. So if you think iron ore is to be separately treated, do that. Then 7. The state government shall grant a mining lease to an applicant selected in accordance with the procedure laid down in this section. So everything not has to be done in accordance with nothing, no rule can be made which conflicts with this 10B. So you can't do this, not that you set out parameters, I make my bids, you execute the NDPA, you grant the lease, we work for 1 year, and then 1A, 1B, 1C comes into the scene. And still 1 year later comes that proviso to 12A, and you want to apply it to my lease, which is a concluded contract. Rights of every party is settled and accrued. That was the respectful submission, which, my lords, this has not been answered. Now, please come to page 3 of my rejoinder submission, which I have given to your lordships. Please come to page 3. 10B I have already read out. This is rule 12.3 of the Mineral Conservation Rules, Concession Rules 2016. Kindly have that proviso at the bottom. Provided that in case of a mining lease granted through auction, the state government shall specify such conditions in the tender document for auction in granting of mining lease. So this complies with 10B, MCR rules. And it also says mining lease is granted through auction. Then rule 8 of the Mineral Auction Rules 2015. 8. Bidding parameters. The state government shall specify in the tender document the minimum percentage of the value of mineral dispatched, which shall be known as reserve price. The value of mineral dispatched shall on an amount equal to the product of mineral dispatched in a month to sale price of the mineral as published by the Indian Bureau of Mines for such of dispatch. The bidders shall quote as per the bidding parameter for the purpose of payment to the state government a percentage of value of mineral dispatched equal to or above the reserve price. And the successful bidder shall pay to the state government an amount equal to the product of percentage so quoted and value of mineral dispatched. Where an area is being auctioned for more than one mineral, we are not concerned with that. So 2 and 3, again, not in the consistent with 10B, you have to lay down what you want. You have laid it down. I bid 115% and I have paid you upfront that amount, which is a substantial amount. The minimum amount which could have been given was 50 crores. It was above that. It is submitted that a letter of intent was issued in favor of the petitioner on 18th of March 20. MDPA was executed on 1/7/20 and registered mining lease was executed on 3/7/20 for a duration of 50 years. The MDPA prescribed the requirement of annual production only for the first 2 years. The mining plan had to be complied with as per section so-and-so clauses. Now let's see the clauses of this MDPA. In case the annual production is less than the minimum production required in Class 8, Rule 8, Clause 8, sorry. Kindly mark this expression, my lords. Nothing about dispatch, production. The successful bidder shall make payment on the basis of final price offer on the shortfall within 20 days from the end of such year. So I was required to pay only if I produce less than the minimum production requirement. Kindly leave the rest so that it defines what the year is. Please have 8, minimum production requirement. There is no question of sustained, etc. production. So that simple, straight production requirement. The conduct of mining operation at the lease area shall be subject to annual milestones listed in Schedule D with respect to production. Bracket, the minimum production requirement. The successful bidder would provide periodic information to the state government regarding compliance with the minimum production requirement in the manner stipulated. Any non-compliance with the minimum production requirement would result in appropriation of the performance security. That is one consequence. In the manner stipulated in Clause 4. And in case where non-compliance with the minimum production requirement exceeds for more than 5 instances during the term of lease, or occurs consecutively for 3 years, such non-compliance shall give the state government a right to terminate the mining lease without prejudice to any other proceedings. So these are the 2 consequences for not fulfilling the minimum production requirement. That's the only thing which is contemplated in MDPA. Now, if your lordship grants me the indulgence of placing 161 of my writ petition 19172. At page 161. This is the Schedule D.
Connection 4, page 161.
That you have already referred.
Your lordships have noted this. I just want to, my lord, for the sake of my submission, just brush up, my lords. Please see, my lord, that minimum production requirement is there.
It's true.
And only for year 1 and 2. Year 3 onwards, nothing. At the bottom, see the clause 12, last paragraph, that table, only 2 years. 18, 19, 19, 20. This is what was the limit of the previous lessee. That's also given.
Yes.
And 12A is quoted.
Yes.
Only 12A1 and 12A2, 1A, 1B, 1C is not there. Proviso is not there. It was not in existence at that time. So, my lord's question is, which I had submitted in the main submission, that since my lease which has been given to me, which is given accrued rights to me, is contemplating a minimum production requirement alone, and there is a penal consequence of a particular kind specified therein for not meeting the minimum requirement. Now, by virtue of this amendments, you are imposing a minimum dispatch requirement in addition, and also going to provide, I can understand that you say that please endeavor to get it, some kind of a directory provision which says that you must make all out efforts. The nation needs some more mineral, as has been argued. It's every mineral will ultimately is used by the downstream industries. So it must turn into steel or some other product, and that's how the nation will gain. So you could have imposed a minimum dispatch requirement. I would have bid it accordingly. You could have told me that 1A, 1B, C will be applied. Had I known, I would have bid it differently. Why should I invest that much money? One would have had it participated, one may not have participated. So you give out certain terms. I participate, I get the lease, I'm selected, lease granted. The terms don't include. The lease ultimately executed doesn't alter this. So my respectful submission. If the Lordship sees the second column, it refers to 12A as it then existed. So therefore, the submission was and not answered by them, that how do you apply 1A, 1B, 1C and the proviso to a concluding? That's the first submission. I had cited Vatika also, which is again not quoted at page 6. Your Lordships had noted that. Now please come to 7. What was the response of the learned Attorney General? One, he said he referred to clause 1.21 of the MDPA. Please have a look at the MDPA, which is annexed to my petition.
134.
1.21. I have quoted, although your Lordship can see from this.
134.
Any reference to any, it's a definition provision, not a substantive provision. Any reference to any statute or statutory provisions shall include: 1. All subordinate legislation made from time to time under that provision, whether or not amended, modified, reenacted, or consolidated. If I may pause here, my lords. So 10B is there. Section 13 and 18 are the rule-making power. They do not give any power to make a retrospective rule. So even if you make a rule with respect to 10B, it will apply in future. If you grant a lease after 21, it will certainly apply. 1A will also apply. But rule-making power cannot be transgressed, because this says you can make a sub-rule from time to time. So therefore, it means that you make a retrospective rule. Power should exist under section 13 and 18 to make a retrospective rule. Lord, whether it is Article 265 or 300A, your Lordship says it's not enough that there is a law. It should be a valid law. It should not be violative of any constitutional provision or a fundamental right. Likewise, a rule should contemplated here is a valid rule. And if you make a retrospective rule, firstly, you have not done that. You have not said it will apply retrospectively. So there was no way that this rule can be applied retrospectively.
Not even the implication.
And in any case, it will militate with 10B, which says you specify everything in the tender offer. Second, such provision as from time to time amended, modified, reenacted, or consolidated to the extent such amendment, modification, reenactment or consolidation applies or is capable of applying. Please mark this expression. Applies or is capable of applying. That's the real test. If a rule cannot be made retrospective, it is not capable of being applied from a back date. It can't alter accrued rights. To any transactions entered into under this agreement prior to the agreement date and shall include any past statutory provision which the provision referred to is directly or indirectly relates. So, I fail to understand how this provision this definition provision enables the state to apply 1A, 1B, 1C and the proviso added subsequently amended to concluded contracts. There was one more provision which they refer to, and that was paragraph 3.1 and 3.2 of the letter of intent at page 126 of my petition. It will be.
So indicate annexure 126 is not a
I'm sorry, page
annexure 3.
118 is the starting.
119. 119 starts at 118.
Starts at 119.
Paragraph 3 says 119. Annexure 3 goes into 118 is in annexure 3.
No. Yes, I'm sorry, I stand correct. Page 119.
Part of annexure 3.
This which is annexure 3, the LOI.
Starts from 118.
Yes, starts from 118. Three says conditions.
Yes.
This letter of intent and subsequent grant of aforementioned mining lease shall be subject to the provisions of the Act and the rules made thereunder as amended from time to time. This was also relied upon to say that forget it, whether, and this the same argument is my response, that these rules should be capable of applying to me. It doesn't mean that you retrospectively change the conditions, financial conditions. Procedural thing, yes, I will have to comply. Supposing there is an environmental issue being caused because of this, the government can issue directions and rules to ensure that pollution doesn't happen. So all sorts of procedural directions you can issue, which will apply retrospectively. But if you want to alter, well, if my submission doesn't find favor, look at the consequences which will happen, which means that now they are empowered to completely alter the lease. Why only this penalty? You can also alter then that instead of having 0.50% of the estimated value of dispatch, I now will take 2% and apply it retrospectively. Because there is a clause of time to time. So the whole contract can be completely changed. So there is some, your lordships have.
According to you, that the amendment is contemplated under this particular letter of intent. That the provision of the law that is in existence or was invoked at the relevant period of time when quoted the price or participated in the tender and the agreement was entered into. The amendment, if any, brought subsequently, will also be included there. According to you, if these are applied with the full force or the rigor, in that sense, that it may at times in a given situation eclipse the existing right which has accrued in you.
Absolutely.
And therefore, if right is I say somehow is taken away, which is according to you is an accrued or a vested right, then by virtue of this is not permissible.
Not permissible. And for an additional reason, if I may respectfully add, is this that under section 13, 18, you do not have the power to make a retrospective rule.
Does it require a power to make any rule retrospective or prospective?
Your lordships
Under
have,
the parent act?
your lordships have,
Or it is a legislative exercise
no, with
within
your
the
lordships.
wisdom of the legislators to think about it, whether the provision should operate the retrospectively or prospectively.
So because your lordships have consistently held that if the law permits, a rule can be retrospective. If the rule making power is plenary under Article 309, is like a legislation, it can be retrospective. Provided it says so. There are two problems in our case. The amending rule 1A, 1B, 1C and the proviso doesn't say that it is retrospective.
Second, what is the harmonious reading or the reading of the provisions to ascertain whether the legislative intent was to apply retrospectively or prospectively? It depends upon various factors.
Correct, nurse.
Even at times it is applied retrospectively, the courts have frowned upon the same and say that you can't apply.
So I concede, my lord, that on an overall reading of the context, etc., your lordships may come to that conclusion that it is actually operating retrospectively. But in our case, my lord, it doesn't, there is nothing in the context, nor does it say so expressly that it will not impact. It is the executive, the mining authorities which are understanding it like that and applying 1A. The central state government is not the rule-making authority, central government.
True.
Now, central government has not said anywhere that these rules are supposed to operate retrospectively. Either because of context or because of express mention. More than that, settled position is that if the parliament has not given you a power to make a rule retrospectively, you cannot make it. I will
You suggest that there should be an express prohibition or a restriction to be imposed.
express enablement.
Well, there are two intendments that comes, either an express or an implied. It may, by necessary implications, one can arrive at the decision whether it is retrospective or prospective. Subject to what the judges.
I will give you lots of those judgments. But in my respectful submission, Lord, the consistent view of the court is that if the legislature has not given the power to the rule-making authority to make a retrospective rule, they cannot make it. And their
Retrospectivity has to be considered in tune or in juxtaposition with the tenet of the parent act.
yes,
That by virtue of making a rule, you cannot make it operative prior in time of the substantive act.
yes.
That is what is something else. Retrospectively, retrospectivity is given on to apply on the date of the coming in force of a parent act, because the source of power to make the rules emanates from the substantive act.
Correct.
So far as the subordinate legislations are concerned, it must emanate from the substantive act.
Yes.
So by virtue of a rule, you cannot make it operative.
Behind that,
The
of
time
course,
of coming in force of the parent act.
that's
There's a
that's
no quarrel
but
to that
I'm going
proposition.
beyond that one. I'm going beyond that and I'm saying, supposing today this rule has been made after 1 year, 1A, 1B, 1C.
This is what happens normally.
Now, supposing this rule had been made after 10 years, retrospectively, which means that I must pay up even for past period.
Then it depends. It can't be said to be in a straight jacket formula that every time it has, but
So-
it has to be considered in that way.
On the facts of each case.
That
That's on
doesn't-
Article 4, annual of Article 14.
True.
Your Lordship may strike it down saying it's unfair now to go back that length of time. I'm not on that. I'm saying your empowerment to retrospectively make a rule must exist in the statute. That's my humble submission, Lord, and I'll back it up, Lord. Right now, I do not. Now, in fact, now if your worship looks at section 13 of the rule making power, there are two, 13 and 18, the learned attorney has
These
said,
are the two sources of power.
and I have no problem to read both of them together. I have no, that was the argument, no problem with it. All enabling powers must be read together.
True.
Correct. So I don't contest that. Now look at 13.
Yes.
The central government may by notification make rules for regulating the grant of mineral concession.
True.
So if this power is limited to grant, you can make a rule regarding grant of concession, not beyond that. In respect of minerals and for purposes connected therewith, in particular and without prejudice to the generality of the foregoing power, rule may provide for all of any of the following matters. But they have to be grant, which is consistent with 10b. So therefore, at the time of grant, you lay down all parameters, everything there. What share you want, based on royalty or otherwise. At the time of grant, not after granted.
Purposive.
Not purposive purpose has to be found from the.
That reminds me always of some judgments of the Supreme Court in this line. Definitely not in context of the mining and all. That is in context of a civil matters. There are two judgments which has come by the Supreme Court.
Yes,
One is in relation to a Nageshwar Majumdar's case. I think Shavita Day versus Nageshwar Majumdar. And another is in connection with the Alita D'Souza's case.
yes,
There the statutory provision was considered where the word which was used in the statute was, say, an incident which may happen but has not happened. Say, for example, it was used as terminable. The word terminable was used. It is open to be terminable. Then the question arose that suppose if it is terminable in nature, may not be terminated. Then in that event, where power and option to terminate, that would come within the ambit of the word terminable. If there is a right to terminate, then in that event, it will come within the purview thereof. The apex court interpreted this word for say that no. Where an option or a right to terminate, giving a that conservative or a very narrow meaning is cannot be spiritual. The one has to understand whether it has been terminated. So the word used was, if it is not terminated, then you do not come. Whereas the legislature was that if it is capable of being terminated, the word was terminable. That would come within the purview of certain protections. So similarly, when you talk about a grant, it is definitely capable of being granted. If the grant means only at the time of grant, or if it is granted,
yes,
and not a precondition stage of being granted, just a reverse situation.
yes.
Then what would be the proposition in that? You say once granted, it is only at the time of grant, not any stage prior thereto of a grant.
So, Lords, pursuant to section 13, the mineral option rules have been framed. This
That's the
section,
2015 regime, that was a paradigm shift
correct.
from that executive exercise to
So two rules came in 2015, establishment of mineral and then option rules. So of how it will be auctioned, what rights will give, a separate regime is there. This is very important
no
because
doubt about it.
now we are interpreting MCR, which is trying to introduce a penalty. No problem. If you have a power, you do it.
True.
So question is, my lord, that in this rule 30, section 13, how do we, my lord, understand that legislature, parliament is giving conferring a power on the central government to make a retrospective rule. That's the point which.
No, I am considering that. That is what I am
Yes.
just thinking.
To Milord's, because Milord's, normally the rule is that if you want to impact a concluded contract, accrued rights, it can be done only by statute. Now look at section 16, where the parliament wanted to impact, they are conscious of this fact. They provided a section 16 in the act, which also what I had shown. Section 16, power to modify mining leases granted before 25th of October 1949. All mining leases granted before commencement of the Mining Amendment Act 1972, if in force at the date of commencement of the Mines and Mineral Regulation Act Amendment Act 94, shall be brought in conformity with the provisions of this act and the rules made thereunder within 2 years. So they wanted to impact the existing contracts, bring them in light with the current law.
Two-year moratorium.
Within 2 years to
two-year
do it.
moratorium period
That's
is
it.
provided.
That may be
Then
held
you
to
have
be
to-
directly.
now, since your position is altered by virtue of those acts, then in that event, it is up to you, your.
To
wisdom
exercise
take a
your
decision.
powers within 2 years, that's a further limitation. But done by act, not by rules. They can't alter the contracts not by rules. That would be very strange consequences. Whatever rule then the executive can make. Even though there is no express conferment of power to do it retrospective, nor it could be done by a rule. Otherwise, what is the value? Let's look at this. So many contracts. So the telecom is there is a contract, exclusive privilege in telecom also. Liquor area also exclusive privilege. Now you give out your terms, people bid thousands of crores. Then you will not by some rule you say that we will impose some penalty or some other kind of a payment which is required. So there has to be some integrity of auction, Milord. There's a huge difference when Milord rule a lease is granted by first come, first serve and by auction. Because auction you set up that transparency requires you set out the term. We bid on that basis. How do you alter the financial terms? I'm not on procedure, financial. In the beginning, you had full rights.
No, so far as the financial terms is not really altered. Whatever the price you have quoted, only your contention is that though not in express terms, it says that whatever the price you have quoted is altered, it will remain the same. But what is an additional obligation which is foisted upon
That's
us?
right.
That instead of production, that is what you do, but you have to also ensure the dispatch. If you do not ensure the dispatch,
Then penalty.
then the penalty. So this is what is
The
something.
two material changes. One, my lease MDPA did not have anything about dispatch. You are bringing in dispatch.
That is what your contention is.
Second is that not only, all right, you are bringing it as a matter of endeavor, understandable. It's not rigid. No financial infliction of liability. But
Then will it not be a farcical exercise? If there is no penalty, if there is no imposition which are there, then the mere introduction of this particular dispatch you ensure is a farcical exercise because non-compliance will not invite any kind of a steps to be taken.
I'm saying
against
that
them.
it is up to the state government to do it, not to do it. But right now, I'm only focusing on this
No, I
submission.
understand. You are focusing that what at the time of the tender, there was no conditions which was imposed with regard to the dispatch. At the
And no
time of the
penalty for
agreement, there was no condition of a dispatch. Even a letter of intent which is there, it does not talks about any kind of a dispatch. It really, all these things talks about the minimum required production.
Production
requirement.
required.
And once you meet those minimum production requirements, then you cannot be exposed for any kind of a penalty or a termination of any kind.
Now, one
Secondly
thing,
is law amended in the meantime, because the law which was quoted has been amended subsequently. This amendment cannot take effect from a retrospective date, affecting my right which has already accrued or becomes vested by virtue of all such exercise which have undertaken by them.
I'm grateful.
This
That's
cannot be.
that's
I
my
think
humble submission.
That is what.
That's my humble
Some
submission,
substance
no, because
of
now
the-
you are substantially altering.
So, and the squeeze, they're summarized in a
Yes,
succinct manner.
absolutely. No. I couldn't do better, no, than so therefore, my lords, that submission has not been responded to by them also. That-
Like those, because that's a very interesting point you have raised. That needs to be, that needs introspection and understanding them. The virtue of a rule without express power being reserved or
I will-
conferred in the parent statute, it cannot
Let's take a look.
be made with a retrospective.
Rationale, my lords, if I may say so with deference, the rationale appears to be this, that a delegate can exercise only that power which is delegated.
True.
They can't travel beyond, you can't assume or arrogate by yourself some larger power.
That's the most first principles
Yes,
or a fundamental principles which we got when we were in a
yes,
law college. There's a very nicely put in the words is an individual can do anything unless forbidden by law.
yes.
And a statutory authority cannot do anything unless conferred by law.
And the other thing is that whereas the parliament and legislature has got plenary powers, the delegate doesn't enjoy plenary powers.
Oh,
So
according to you, that is the prerogative of the courts, plenary power. Not
that's in the
not-
context of judicial review. And your lordships have laid down so many principles of self-restraint, etc. Otherwise, sometimes the courts have also, the Supreme Court has gone on to lay down the law.
No, I'm just reminding myself of my own judgment which I delivered in the other court.
Yes.
Then the question that as an appellate court, as an appellate bench, I heard, so not an appellate court, is an appeal bench. The order comes saying that I exercise my plenary powers and direct this. So then I had an occasion to deal with that there are three kinds of a jurisdiction which the courts of the countries enjoys. That was a territorial, pecuniary, and inherent jurisdiction, which is akin to a plenary jurisdiction to some extent. And then the difference between this, the first two jurisdiction can be waived by virtue of a provision under the Code of Civil Procedure as well.
Yes.
I believe section 21 of the Code of Civil Procedure. Territorial and pecuniary you can, but so far as the inherent of the plenary jurisdiction, that is inviolable. It cannot be undermined in that way. And more particularly the inherent, which is the jurisdiction in relation to a subject matter of the dispute. That cannot be undermined under any circumstances. Reminded of the Kiran Singh's judgment of 1954 Supreme Court, I believe, if I am not wrong, that was there. So plenary, how far the court should go and what is meant by the plenary, I think that has been decided by me in that judgment.
So in one sense, as the worship puts it, well, even the parliament, one can say, doesn't enjoy absolute powers of lawmaking because that is subject to fundamental rights and constitutional provisions. But it is plenary in the sense that they can do retrospective and prospective also. And the field of legislation is construed liberally and widely so that you can make all sorts of laws. But we don't need to go there. We don't need to.
Anyhow, that's a more debatable question you have raised. I do not want to make any
No, I'm not
observations thereon.
I'm not requesting your lordships to go into that much. I'm simply saying which your lordships have succinctly put. Now, please look at Now, kindly, note one query was raised not with regard to 12A, if the lordship turns to 12A itself. Yes. Now look at below the footnote of 1A, 12 capital A, 1A. They were introduced by GSR, dated so in 10th
With effect
June.
from 1st July 2021.
Ahead, date is not even 10th June, but from a later date.
True.
And nothing has been shown by the respondents that this rule is actually intended to be. That's not even the case set up, nor argued before your lordships, that this is intended to operate retrospectively and impact the concluded contracts.
True.
And similarly, if your lordship has the proviso, the GSR 397, 10th June 2021, 1st July. So from a date which is subsequent to the enforcement of the rule rather than back. And nothing not shown, even the GSR has not been produced to show that there is anything in the GSR which compels not a putting of construction that it is to impact concluded contracts. Absolutely nothing. Now let's see about let me assume now, alternative case first. Let me assume by some method of stretched logic, etc., or some assumption, presumption, which the respondents want to make, that these provisions are to apply even with respect to. Now look at in terms. My lords also put a query to me whether, if you look at the context, can you say it is to operate? Let's see. In case of shortfall in dispatch from the minimum dispatch required under sub-rule 1, which shall be assessed on a quarterly basis. Now, please mark this expression, Mr. Singhvi also emphasized, required under sub-rule 1. And sub-rule 1 is only first 2 years. So there is no intent expressed here to go beyond 1. How do you impact 3rd year to 50 year? There is no intent. The context also does not show any intent to apply it even prospectively from 2nd to 3rd to 50th year. It is 2 which says the new lessee shall ensure that annual production beyond 2 years. So from 3rd to 50, only 2 applies, only 2. 1 and 1A, 1B, 1C in terms don't apply. My petition is for 3rd and 4th year. So I don't have to look at 1, 1A, 1B, 1C. Only 2. Second verse. When 1A was not there, it is not that no action was contemplated along with MDPA.
But sub-rule 2 also
has a proviso.
was
now.
a proviso attached to it.
I'm coming
And
to
the proviso clearly stipulates
80% of dispatch.
80% of the dispatch.
But where is the consequence for us?
So now suppose if there is something which is not there in an enabling provision, but by virtue of a proviso something is there, then what would be the impact or what should be the tool, interpretative tool the court should use in
Now,
harmonizing both the provisions, the proviso?
there is no requirement to harmonize 2 with 1 and 1A.
No, proviso with the enabling provisions, sub-rule 2.
So let me now focus only on 2
True.
and 2 along with proviso.
Correct. Enabling, the main provision talks about the production after 2 years, then how it is to be done. And it only talks about a production. It does not talk about any dispatch in the main part of that sub-rule 2.
Yes.
But subsequent insertion of a proviso, that the dispatch is also treated
now,
as a part thereof.
When inserting the proviso, it was open to the central government to adopt the penal provision of 1A for 3rd to 4th, 5th, 6th, up to 50. See, look at the choice with the central government. Do you want to extend it beyond 2 is the first choice, which a rule-making authority will make. If I want to go beyond 2 years with a penal clause, should it be for up to 3rd, 4th, 5th, or right up to 50? Should a line be drawn, not drawn? There is complete absence of any indication that 1A is to apply to 2. Neither 1A says it will apply to 2, nor the proviso says. Look at it from both angles. Neither 1A is saying that it will apply to 3rd to 50, nor the proviso is saying that it will have a penal consequence just like 1A. It is for you. You have 39B and all those things which have been said. We were nowhere in the scene, not even now. Even till today, my lord, there is no amendment to say that 1A should apply. So, as has been submitted already, my lord, we have to go by the words used. Especially when it is penal provision, my lord, the court will be loath to extend a penal provision to a situation where it is not provided for. My Lord Justice Shriram was pleased to put a query, my lord, whether casus omissus will apply. Now, first, my lord, it's not a casus omissus which is inadvertent. Can we assume that the central government has consciously avoided to have a penal clause under 2? And it's not that there is complete absence of a procedure for non-compliance. Look at this. May I again draw your lordship's attention, provided that the new lessee shall also ensure at least 80% of such annual production. Just that word, such annual production, takes us to the main part. Because
True.
now, come back to the main part then, kindly come to that. New lessee shall ensure annual production beyond 2 years from the date of execution of new lease equal to or more than the annual production by the previous lessee and shall subsequently work out and implement an annual production plan to ensure that the mineral resources are fully exploited during the period of the lease, failing which appropriate action in accordance with the mine development and production agreement shall be initiated. So there is a
Penal provision.
there is a provision. So you take action under, if you so feel,
That is what they say, that we have taken that action.
under the MDPA. And MDPA has a consequence of shortfall of production, but I'm assuming now against myself, in their favor, that production includes dispatch there. I mean, it's a whole lot of to where we are assuming so many things that my MDPA, which is focused only on annual production, minimum production, should be read as dispatch also. Having read as dispatch, then the penal provision which is not there, 1A, 1B should also be applied there, instead of the action which is contemplated under the MDPA. How this is complete legislative exercise which they want from the court. And your lordships have said that courts will not rewrite cases omissus cases. Let me just give an extract of it is attached to the written submission notes. Instead of reading all of them, but your lordship said that normally it should be read from beginning to end, but then paucity of time.
No, that is why my exercise, not for you. My exercise, that I always read from the first line to the last line.
Equally. And kindly have alert, this is
Why your junior has not paginated this?
yes, sir. Kindly have the last page, no?
When you are referring anything,
I apologize.
Serial 9. Serial 9.
Serial number 9. That is the second last page. Serial number 9. I
No,
apologize. I'll do that paging.
That's
Yes. Union of India versus Rajiv Kumar, 2003, 6 SCC 516. While interpreting a provision, the court only interprets the law and cannot legislate it. If a provision of law is misused and subjected to abuse of process law, it is for the legislature to amend, modify, or repeal it if deemed necessary. The legislative casus omissus cannot be supplied by judicial interpretative process. Two principles of construction, one relating to casus omissus and the other in regard to reading the statutory provision as a whole, appear to be well settled. Under the first principle, a casus omissus cannot be supplied by the court except in case of clear necessity.
true,
When reason for it is found in the four corners of the statute itself.
true. That is what is the
So
main.
And therefore, I am submitting that here we are dealing with not a statute but a rule, and the rule neither 1A says it will apply to 2, nor the 2 itself will not either in the main part or the proviso says that 1A should be attracted. So by assumption, a new kind of penal provision never intended to apply to 3rd to 50 years is sought to be applied here.
This is giving more.
Now, in my writ petition also, page 24, I have given some more cases. This one I just took out.
Written submissions.
Written submission.
No, you have referred many judgments on a different proposition of law. You have referred it.
No, at page 24, cases omissus I have referred to.
Written submission.
Page 24 of my written submission.
Original or the today's.
No, just one today.
That is the whole problem because it is not paginated anywhere. It's
No,
been,
my written petition submission is mentioned. Not this.
which is,
At page 24 of the main submissions. This is a extract.
sorry.
I apologize.
Oh, I understand. Yes. That is the Union Rajiv Kumar's case.
Yes.
Then
Which I read
Prakash
out.
Gupta.
And there are 2 more cases mentioned there.
Rajiv Kumar relating to that the automatic suspension. Rajiv Kumar's case,
Yes, yes.
automatic suspension. If you are detained beyond 48 hours, then automatic suspension. And then until further order has been considered in, I think there is one Rajiv Kumar's judgment. Maybe I am confused.
I have separately given a compilation of the judgment. Maybe is correct.
My Lord, the Chief Justice is right.
That's one of the very celebrated judgment
Yes.
on that whether automatic suspension because of the detention more than 48 hours, it is there ingrained and inured in every I think the government, the service, that once you are put behind the bar or not bar, and you are there, then automatic suspension. Then until further order means, does it continue for all time to come, or there should be a periodical revision or a reconsideration to be done by the
Yes.
authorities,
Yes.
whether to extend or not to extend? I think that was a principle.
That was the case.
Yes.
So the submission is this, that
No, you sir, sorry. Just I read it, so it is struck in my mind. I just forgot. Don't go by that.
On cases, so Mrs. I don't have to add anything
Yes.
further.
Yes.
This Rajiv Kumar very clearly is, which I have quoted. There are two other judgments in my written submission, page 24.
Yes.
For Rajiv Kumar, very clear, that if supposing your lordship comes to a conclusion that, sorry, the central government has faltered. But you don't know it has faltered. I would put it like this, that it is not a case of omissions, but a conscious omission. Because for 3rd to 50 years, and the reason was given by Mr. Sidney, which I may just reiterate at this juncture, that is, that supposing the rationale was that, look, we are giving you the benefit under Section 8B, the vesting order, all approvals of the past lessee, previous lessee are extended. Initially, it was 2 years, then 8B was substituted, and they said for the whole period. Now, if that is so, not supposing there was no such provision, it would have taken 2 years or 3 years to get the approval. And then it would have operated for 50 years in any case. Here it is statutorily given to me for 2 years and then extended. So that logic does not enable the extension of the proviso by adding. So it's an expansionist. The respondents from the learned counsel, the learned attorney general, and they have really, are requesting your lordships to add, to rewrite, to extrapolate into this provision 1A there. By no method of interpretation or construction, something which is not there, that too when it is penal can be done. So my case is that whatever, how so liberally we may read, what is absent cannot be provided by us. It is for central government. Even today, let them provide if they want. Only 5 years have gone. Why don't they amend it and say that 1A will apply? If they can do that, do it. And I would submit they can't do it. For accrued rights are impacted. But if you want, do it first, then ask the court to uphold it. You can't say, I am not doing it. I am not expressly saying so. On the contrary, the rule is providing otherwise only for first 2 years. But court may do it. Why? Because otherwise there will be hoarding. That's the third red herring. Hoarding will happen. If 1A is not extended, then these miners who have spent hundreds of crores to get the lease.
No, Dorkan, there's no need. Why you are going?
Who have spent hundreds of crores to get the lease to establish the plant. And now I am required by the IBM in the modified plan to have a beneficiation plan because hematite is not available. Magnetite, which is a lower grade, is available in the area. So the mining plan has been changed. We will not resort to hoarding. Capitalism, my lord, is based on the maximization of return. And everybody produces a commodity to sell it in the market and get back the investment and make some profit. That's the normal rule of business, my lord, whether it be go by Adam Smith or we go by Karl Marx, whichever be the method. Nobody keeps on inventories. Nobody likes inventories in the... And where is the space? I have a limited space in the area if I go on hoarding and hoarding. And what are your inspectors doing? You have a power to preemptively take it away if I am hoarding. There is no whisper, not a single line in the affidavit of the union and the state saying that any of these petitioners, we are previous lessee also. 50 years we have operated, not a single notice that we have hoarded. Nobody against how many cases, not a single case has been cited that look, there has been hoarding. And the paradox is this. Look at the paradox. They say that this penalty is required because hoarding, which is not happening. Then they say mining plan is just technical, not mandatory. So rules and act can say go beyond. First, they don't say, the rules act doesn't say that. But common cause judgment of Supreme Court, what was it? There was mining done by so many
Without any authority or
Over and
contrary
above the
to
mining plan.
contrary. There are two situations. One is without any permission or a grant or a lease. Second one is that extending beyond the period of a leased area.
and beyond the mining plan.
That is what is.
And Supreme Court said this is illegal, liable to 100% of market price as penalty. I appeared in that case for the state, my lord, and the 100% was imposed, and everybody had to pay it, fork it out. And Justice A.K. Patnaik was appointed as a chairman of a committee, my lord, so that this money can be used for the people who are engaged in the mining. And his lordship did not charge a single paisa as fee, my lord. He refused because it's for poor people. So therefore, my lords, look at the paradox, my lords. That which is happening, which is to be stopped, illegal mining, they say you can do it, mining plan is that. But here you say hoarding. Let me accept, Lord, it is because of hoarding you have done it, brought this 1A. Is wholly rational is 1A. Hoarding. Because union says in the affidavit, even if it be in one line, some weight has to be given. Now, let us see 1A, Lord. How does it say? Where does it say, Lord, it is limited to hoarding case only? It's an absolute no fault liability. There is no investigation being done, Lord. Demand notices are being issued without any notice or opportunity of hearing to demonstrate that no charge being leveled against us that you have hoarded or that you are negligent in any other way. Supposing, my lord, because of pandemic, the workers go away. So because of long drawn labor strike, my lord, there is non-production. Supposing, my lord, there is a change of policy by the central government, they say no more exports, the market shrinks. Supposing a new product, my lord, better than steel emerges in the market and the steel production alters the course. So many cases you have given leases to captive owners. They are happy with their mine. They are not compelled. There is no provision that these steel makers will necessarily buy if I approach them. No provision. So supposing they refuse, I go to my lord MTC, please enable us to sell it. They say no, this is inferior grade, can't be sold. There can be n number of bona fide circumstances, my lord, where a lessee may. There is nothing in 1A to distinguish between a fraudster who is hoarding and a person, my lord, who is afflicted by vis major, force majeure clause, reasons beyond control. Where should I dispatch, my lord? As the lordship said, can I take it, my lord, to and put it in some other place and dispatch it and pay and then hold it somewhere? I can't do that. So I must have a buyer. But I'm saying nothing. Please do rule that 1A postulates an inquiry. This word failure is not a word, not which means absolute no fault. My lord, Mother Earth, if it doesn't give me hematite, gives me magnetite, I have to do with it. That's in my leased area. Nobody can help that. So, will there be a show cause notice for me to demonstrate that, look, there's no fault of mine, for the reasons are beyond control? But they say, no, it's so the assumption of hoarding is a red herring. It's just not there. It's not meant for that. You just want to extract some money irrespective. And look at what is being charged. Lords. They want lordships to read it into the proviso to 12A2. They are royalty, TMF, NMET, all those things, Lord, which are supposed to be paid only on removal, all that are included. So it's a heavy penalty, not to be read by implication, contextually or otherwise, and the context doesn't support them. At page 277 of my writ petition, just to get an idea about how the demand notices are.
Yes,
At page 277, just from
that
three
a
lines-
block, within the block, it says different.
Can we have from 3 lines from the top? Provided that the new lessee shall also ensure 80. So the proviso is quoted. In this connection, provisional demand notice amounting was issued, but you have neither deposited nor submitted compliance. And what are being charged? Differential amount payable towards applicable amount quoted under Rule 12 of Mindol Auction Rules, 43 crores. Differential royalty payable, 5 crores 66 lakhs. Differential DMF payable, 56 lakhs. Differential NMET, 11 lakhs. Value of performance security, 9 lakhs. Ultimately, I pay approximately 60 crores. So 60 crores is the penalty for, because the Mother Earth gave me magnet right and I was compelled and forced to get my mining plan modified. And the IBM says you must get a beneficiation plan before using it. Magnetite cannot be used for steel, and steel is their argument. These facts I don't want adjudication, but I want that there should have been some scope for inquiry under 1A. They are applying it as a no-fault absolute liability, which is completely manifestly arbitrary. You don't want to investigate even whether what is the reason for buying. So that is the substratum of
I believe that is what your endeavor is to focus upon.
yes.
So you have gone through, you have really highlighted those aspects from a different perspective,
Yes.
in the perspective of the present fact.
Yes.
So we have gone, I have just hurriedly gone through it and definitely will go deeply
Yeah, I'm
into
sure
it,
you'll also look into it.
deeply go into it. Hmm.
And there were two other issues, not much has been said, namely, whether production, if your lordship gives me just 5 minutes more, then I'll finish.
Yes.
If your lordship looks at 12A, you have rule 12A once again.
Yes.
Now, see, 1A uses the expression in case of shortfall in dispatch, etc., which shall be assessed on a quarterly basis, the lessee shall, in addition to amounts payable under 13, oh, I'm sorry, 12.1, 12A1, please have 12A1. Notwithstanding anything contained during the first 2 years from the date of execution of new lease, the holder of mining lease to whom vesting rights have been given under section 8B shall maintain such level of production to ensure minimum dispatch of 80% of the average of annual production of 2 immediately preceding years on pro rata basis. Please mark this expression. Average of the annual production of 2 immediately preceding years on production of
On pro rata basis.
Now this is completely missing in 2. 2 doesn't say that two previous years.
No, it says beyond 2 years. So naturally, the word beyond.
But it does
Cannot.
say annual production by the previous lessee.
But
It's
that
a
is where,
different-
because the argument was that there was a paradigm shift from the earlier regime of granting a mining lease to a auction regime that came in 2015.
Correct.
So all the leases which expires, and then because of the auction regime, it has to be done through an open, transparent, and fair manner. There is a possibility that the existing lessee may compete and emerge as a successful
Or some new
bidder in the process, or there may be a new one.
Absolutely.
In both the situations, I think the harmonious reading of one is that you have to at least maintain the same level of production which was doing and earlier lessee was doing, and immediately preceding 2 years, that is from the date when you start, preceding 2 years. So then you'll have to match it and then say 80% dispatch. There, I understand, hypothetically, one can also think about that the old lessee does not emerge successful. The new lessee is coming. Then also, he is not aware that what is happening there and what is there. Something which is very new to him. He has to go and find out what are there, how to make a plan, how to do it. So at least these 2 years period was provided to him so that don't go for a higher one or a lower one.
Right.
What he was doing, just match it so that at least that is done.
And the rationale very clearly set out and very fairly also submitted by the learned Attorney General was, the other logic was that since the vesting order gives you all the approval of the previous lessee,
That is what
the
he says.
intention
No,
is that there should be continuation of production.
absolute.
Agreed. No problem, Milord. We agree. I agree. At least I agree, Milord. I do not know about others. But I agree with this, Milord, that the intent was, that's the only logic,
True,
not hoarding.
true.
So normally, Milord, it takes 2 years' time. That was the assumption. Therefore, they said that for 2 years. Later, when they extended it, because of that extension, which normally in any case happens, Milord, once I get approval, then I don't have to go on getting approval. Then it operates on its own. Ex proprio vigere. Therefore, this further extension to 3rd to 50 years is governed only by 2. And that's the reason, Milord, why
That is what it says.
dispensation
You
has
can't,
been
yes.
brought in, Milord. Now, 4B, Milord. So there were some IBM letters. Mr. Singhvi has shown, Milord, that confusion business had there. But when the rules are to be interpreted, ultimately, Milord, your lordships will look at the textual thing and see, Milord, how best to harmonize it. For sure, Milord, 12A2 main part, to some extent, Milord, is hazy, vague and confused. So there are 2 doctrines, Milord. One is of Lord Denning, Milord, that if the judge is confronted with a crease,
Then iron out the trees.
trees. But if there is a complete hole, Milord, then it's not the job of, there is a case of omission, Milord, there's a big hole, that can't be, Milord, planned. So the crease can be ironed. Whether it will be a matter, Milord, falling within the ironing of crease, Milord, or not, I will not leave it to your lordship. But for my purpose, it's enough to say that 1A, 1B, 1C,
Understood.
that cannot be applied to 2 at all
Yes.
on a plain reading.
No, I got your point.
That I've said, no. My learned wants to again re-stress for that they are picking up the last 2 years the first 2 years figures
Uh,
and applying
that you have already argued.
Now, the other thing which remains, but I don't want to repeat that argument of 4B existent or not existent. I have said something. Your Lordship will examine it, my lords. I don't want to get into that again. Except to say, my lord, again, to I adopt Mr. Singhvi's submission about 4B production, sustained production. Whatever emphasis and adjectives may be used to production, production remains production, my lord, it doesn't become dispatch. And this logic, my lord, there's one more reason which may add, my lord, to that. Before dispatch, there must be a sale. Has to be, my lord. I can't dispatch like they were. So do we mean to, the respondents want to contend that production means that there must be a sale, compulsory sale of some kind? You have not, the state has not created any body, my lord, which will compulsorily buy if it is not being sold in the market. So production, before it jumps to inclusion of, it's a hop, step and jump. Production must follow with a sale and then, my lord, thereafter there will be a dispatch. So we are also assuming that production is including a sale and therefore also including a dispatch. Of course, once it is a sale, then dispatch will necessarily follow. But there is too much of a hop, step and jump in the world. Too much of an expansion all around. It seems not that they are faced with a situation where the rules and the laws are not contemplating, but at every point you want an expansionist construction to be put. Why? Because 39B and that we are not, it's a unilateral determination of how the contract will be executed, how the auction will be held. You are the master of the ceremony. Unilaterally, you decided. Now you want an expansionist construction not to impose a penalty. I'm grateful, not
So you start, you're coming within.
the statute permits. That is 2021, volume 10 SCC. 2021, volume 10 SCC 210. Para 17 and 18. At page 219 is para 17. Another equally important principle applies in the absence of express statutory authorization. Delegated legislation in the form of rules or regulation cannot operate retrospectively in CIT versus Pannuls. The courts will not therefore ascribe retrospectivity to new laws affecting rights unless by express words or necessary implication it appears that such was the intention of the legislature. Parliament can delegate its legislative power within recognized limits. Where any rule or regulation is made by any person or authority to whom such power has been delegated by the legislature, it may or may not be possible to make the same so as to give retrospective operation.
Yes. By express or necessary implication, just say.
Yes. So you also will have to read that was some necessary implication, you can make a retrospective. And then you should be making a retrospective. I'm grateful.
The third matter, this serial number 3 in this bunch of matters, that's the case where the petitioner is yet to be heard. He is a new merchant miner. Serial number 3. 30039 of 21.
Yeah.
But, what I intend to argue has been substantially covered. 3009. 30039 of 21. Third matter in that one. Well, it's what I intend to argue has substantially been covered by my esteemed senior Mr. Subramanian. Because we stand on a similar footing. And I adopt the submissions which have been made by my esteemed seniors, the matter with regard to challenging the vires of the statute. But over and above that, there are certain peculiar features in my case which I intend to put before your lordships. Now, let's for doing that, I'll straightway take your lordships to page 368 of my brief. Page 368 is the point is this, Maraj. Apart from I am in the first year. My lease commenced on the 2nd of July 2020. And the demand is for the first year up to 1st of July 2021.
Mr. Subramanian's.
Exactly. That part is covered. Now, my lords, because of 1C, it clearly excludes if me from the 1A, the impost contemplated under 1A. So I go out there itself. But over and above that, there are since I'm a new miner, there's certain features which I had pointed out to them in my show cause, reply to the show cause, which indicated that I am not liable even for that amount, which is provided for as per the production targeted because of force majeure. Now, my lords, for that, I will just take your lordships to two sets of documents. If your lordship takes clause 17 of the NDPA, which is at page 210 of this brief. This is part of the mining development plan. Now, event of force majeure.
Yes.
Event of force majeure means any of the following events or circumstances or combination of the following events or circumstances which are beyond the reasonable control of successful bidder, which could not have been prevented by good industry, etc. 2. II, epidemic or pandemic. Then next, that's not all. 3, there is civil commotion. And VI is any labor or trade dispute. These are the features that I will point out to your lordships are peculiar to my case. Now, if your lordship takes 17.2, it says the last two lines, the successful bidder shall not be in breach of this agreement or otherwise liable for any of such failure or delay in the performance of such obligations. 17.3 says, as soon as reasonably practicable after the start of the event of force majeure, but no later than 30 days from its start, notify the state government in writing in the event of force majeure the date on which it started, its likely or potential duration, and the effect of the events of force majeure on the ability to perform any of the obligations under the agreement. Next, your lordship takes 17.4. If an obligation is suspended by reason of an event of force majeure for more than 1 month continuously, the party shall enter into good faith negotiation to revise the terms of the agreement to reflect the change in circumstances, provided that this agreement shall remain in effect during the period during which the parties are negotiating the terms of such revision. Now I will show to your lordships the relevant documents to this effect. Your lordship may kindly see Annexure 6 at page 242. Well, before we go into this document, I would again reiterate the fact that I am a new miner, as opposed to the other petitioners who are established players in the region. Now, I am a person who is coming in new, setting up an office for the first time, recruiting work personnel and labor for executing the work. Now, having come in here, 9/7/2020, page 242. Government of Orissa, in exercise of powers conferred under Section 234 of the Epidemic Diseases Act, has promulgated Orissa COVID-19 Regulations 2020 for containment of COVID-19. Now, Your Lordship takes the fourth paragraph. Whereas the 9 positive cases of positive COVID-19 have been detected in so-and-so Rungta mines of Koira block. Koira block is where I am operating. Next, Your Lordship sees this continues at page 244. Does not bother Your Lordship. Again, there is another notification at page 248. It continues, my lord. And page 256. What I read out from the MDPA. Now, Your Lordship may take page 257. The third paragraph of that page, as per the MDPA agreement, page 257, Your Lordship does that. Your Lordship, at the previous paragraph, I invoke MDPA agreement clause 17, and then I go on to say, as per MDPA agreement in clause 3.3, it is stated that the date of commencement of period for which the mining lease is granted shall be the date on which the duly executed mining lease is registered. Our mining lease was registered on 2/7/2020, so that the period of commencement starts from 2/7/2020. Further, as per clause 5.1a and b, the commencement report and the periodic reporting is not able to be submitted due to the above said reasons. At the same time, as per the MDPA agreement 9.2.2, we have taken all necessary actions to obtain fresh mining plan approvals from IBM. Then, my lords, the last paragraph at page 258. Therefore, we request your kind self to consider the above facts and present situation of COVID-19, and as per the act of God, and
You wanted a revision of
good faith negotiation. Good faith negotiation. Next, Your Lordship takes 273, my lords.
That period is before.
After the pandemic period, I get out of that period. First wave of pandemic is over. I give on 14/10/2020. I give notice of opening of mine. Then, my lords, kindly take page 282. 282.
Yes.
Lord, this is a letter which I give to the Director, Department of Mines and Geology on 2/11/2020. It's immediately after seeking to reopen. About second paragraph, fourth line, Your Lordship, third line, Your Lordship takes. As scheduled, opening of the mines was started on 23/10/2020 and commenced the work. Few people from nearby villages and local leaders interrupted and stopped operation of our mines and blocked our gate. 282, madam.
17.
Annex 7, second paragraph. As scheduled, opening of mines was started on 23. Yes. Few people from nearby villages
Develop CR1, could allow us.
start the mining operation. Next, Your Lordship sees the proceedings of the meeting at page 283. This is district administration convened this meeting. The meeting was chaired by the sub-collector Bonai. Initiating meeting, he started the PM Granites, that's petitioner, the lessee, the letter dated so and so regarding local problems they're facing. Then Your Lordship takes the next paragraph, last 3 lines. The company is supposed to produce targeted quantity of manganese ore as fixed by the state government. Otherwise, they have to pay huge penalty. The local problems need to be sorted out to allow them to operate the mine. Thereafter, last paragraph at page 284. However, the demand of the villagers of different works were discussed and sub-collector assured to take up the matter with collector and district magistrate of Sundargarh for further course of action. Then Annexure 19, page 286. This is a letter written by the director of mines. In reference to, and so I am to say, the obstacle created by the local village in carrying out mining and allied activities in the leasehold area is a law and order issue which needs to be resolved through the district administration. And then at page 287, after it is resolved, on 16/4/21, I intimate them. Now we have commenced our mining operation once again from today on 16/4/2021. So, my lords, even though I came into the lease on 2/7/2020, till 16/4/2021, I was unable to operate the source because of certain circumstances which I have pointed out from the MDPA, and I wanted good faith negotiation for which I had given them notice in terms of the MDPA. Now, my lords, that did not happen. And when this was pointed out in the show cause, which they had served on me, I responded to them, wherein again I reiterated all these issues.
Page 345.
Kindly take page 345. This is my show cause, which runs to 20 pages. I will not bother your lordships with that. But how they deal with it is at page 370. Page 370, the paragraph that begins on that page. And whereas you personally have attended the hearing and submitted a reply of the show cause notice, why your letter number so and so dated, which is not satisfactory as per law, that's it. And this, my lord, has been decried by this honorable court in the first round of litigation at the instance of the petitioners. That's one judgment, my lords. I'll pass on to your lordship. My lords, this is a judgment where very similar issues were raised, the first of force major. And if your lordship takes paragraph 76 at page 105. Considering the case of the petitioners from the perspective that despite peculiar and different facts of different cases, non-consideration of each individual cases separately invoking 12(1), it should be FF, not GG. While the representations of the petitioners were pending, while order dated 1/10/2020, and then rejecting all the representations by identically worded cryptic and non-speaking orders while order dated 9/10/2020, this court is inclined to hold that is a fit case for it to exercise its power of judicial review by requiring the respondents to reconsider the representations of the petitioner, at least for the first 5 of the above writ petitions, anterior to the stage of invocation of Rule 12(1) GG of the rules of 2016, when such representations were pending with them, and straightway allow last 3 writ petitions, wherein the petitioners have either not invoked force majeure events or have been otherwise able to make out a case independent of application of force majeure clause. On account, the first 5 cases that invoke force majeure. On account of arbitrary exercise of powers and lackadaisical approach and abject apathy on the part of the state functionaries to their case by not applying their mind to the representation and mechanically rejecting them as not maintainable. Para 77. On analysis of the entire materials of
And the disposal of the representative was yours.
Yes. And now if your lordship comes back to page 370 of my writ petition, the impose that has been put on me,
Is on, according to you, is a cryptic order, they have not spread out anything about it. What about the procedure, the different letters issued by the authorities, so were not taken into consideration, straight away rejected, not satisfactory and improved.
and page
4413.
413, your lordship may kindly see, even the Ministry of Mines, they have also this is the invocation of force majeure clause in the mineral development and production agreements. I am directed to bring to your kind notice about the unprecedented situation caused in the country due to the countrywide lockdown, the COVID-19 pandemic. The mineral industry has brought to the attention of the ministry about the adverse impact of restrictions imposed on travel, transportation, mineral production and demand. There is a demand from the industries to invoke the force majeure clause in mineral development and production agreement and to the assets and the quantity of minerals.
Take into account the ground realities that has happened globally.
And another document is at page 417.
Or
This is Ministry of Coal, which is in view of the force majeure request in line with the allotment agreement,
that we are not concerned with the core department.
but it's a ministry and they have passed it on to the industries, PSUs. Now, if your lordship sees the demand at page 370, apart from the fact that on one aspect that my show cause has not been looked into and a very cryptic order has been passed, if your lordship sees the impost also, the serial number 1, that is in terms of 12(1)(a). 12(1)(a) does not apply to me. Serial number 2, 3, 4, and 5. This has been argued at length under section 9. It will come only at the time of dispatch. These are royalties. Does not arise on production. So it's that apart from the submissions which have already been made, which I wholly accept on behalf of the petitioners. And these facts have not been traversed in any by the explainer.
Your Lordships, quickly respond. Not that I'm insisting on a sir rejoin.
The reply.
No, but there's an additional submission
What additional?
to notes schedule requirement and senior. Yes.
It will be,
You are definitely,
No, only where
I will give a reply.
small funds were adding, nothing more.
Given an opportunity to.
I don't claim a sir rejoinder opportunity.
that is the whole difficulty. If you add it, then again,
No,
opportunity.
I'm not adding anything. I'm not adding anything. Since this matter has brought in certain very important dimensions of interpretation of a seminal piece of legislation for the country. So I think occasionally your Lordship will give us the indulgence by saying, since I've opened up the subject of saying, how do you read section 4B, 8B and rule 12A?
But that's true that you have already argued that.
Yes, that's right. I only want to place note for your Lordship's kind consideration.
Yes.
If that note would probably part of my written submissions earlier. So I asked myself a question, only one question, and I'll complete my submission. If section
What?
I thought Lordship was reading my note.
No.
I asked myself only
No,
one.
I was just trying to figure out that word like a deha without a dehi.
That is Justice Krishnaiyer in a judgment talks
Yes.
about deha and dehi, the soul and the body. It's one of his well quoted.
Yes.
judgment. And Justice Chinnapradi in the PLS case talks about the text and the context.
Yes.
They all try to convey the same object. Now, I asked myself a question: if Section 4B was brought into the statute for a certain purpose, and that came in January 2020. These are all leases subsequent to January 2020. Section 4B says central government is competent to prescribe in regard to what shall be the sustained mineral production. Therefore, 12A1 and 2 come in March 2020, right? So thereafter, 1A, 1B, 1C added in 2021 in order to provide for a continuum so that there is no lack of attention to what should happen immediately after the 2 years. Therefore, the entire corpus of Rule 12A is to ensure that Section 4B realizes its purpose. Then there is no question of any retrospectivity, etc. There is no question. Nor I have tried to canvass a proposition. There is a casus omissus, try to supply words and things like that.
Yes.
The distinction between a casus omissus and any principle of interpretation where courts will read either meanings into words which are otherwise capable of being read into, or where the court may add a particular word only in order to add meaning to the word already.
Reading down the statute principles.
That's one way of looking at it. Reading down where a rule would be offensive to reading down a rule where offensive to a constitutional provision, I read it down. So I am not saying
I use the very, very common phrase in a legal parlance. That's why.
That's right. I am saying something else. If you put all these principles of interpretation together, whether it is casus omissus, court will always add some meaning. Where a word is missing, court can add a word or something like that. They are all court-created principles of interpretation. They constitute corpus of principles of interpretation. They are not to be read like statutes.
Yes, originating from a common law principles.
That's right. Therefore, if there can't be tomorrow, like a general clause act, if a parliament enact a law, you will not interpret it in the following way. That law will fall foul of judicial review powers itself. Therefore, what I'm trying to say is Section 4B is necessarily followed by Rule 12A, 1A, 1B, and 1C, and 2 is a corpus of the law necessary to ensure sustained mineral development takes place in the country.
Yes.
If you take away Rule 12A, then it is like a limbless piece of legislation.
Yes.
4B becomes a limbless piece of legislation.
Yes, that's true.
That's all. So this note I wanted to place large kind of consideration.
Yes.
And when he said that Mr. Gopalakrishnan has said that you can't have statutory interpretation of the penumbra rule, I don't think any principle of interpretation or a limitation on the courts bringing in a certain rule of understanding a statute can there be a limitation on that.
Yes, yes.
Whether it's constitutional law or statutory law, the penumbra principle is only that. Please look into what shades of meanings, what connotations a statute or expression may obviously connote in a given context. That's all I said is therefore applicable to penumbra.
Yes.
I just leave it at that. I don't want to elaborate.
Thank you.
I'm grateful to your lordships.
Thank you. Yes, then we conclude the hearing.
We're grateful, my lord.
Yes. Hearing concluded. Judgment reserved. Yes. Until judgment. Yes.
79.
What is there in the 79? No, it has to be fixed somewhere in this week. I think that he says that he should fix the matter in any week.
I am appealing for the opposite part. And today I am filing my counter. Counter application.
Anyhow, file. Do you have the copy ready with you?
Yes, I have already. I have solved it. I have solved it.
So do they like file rejoinder?
Yeah.
Would you like to file rejoinder? You are appearing in 79.
Yes.
Would you like?
Casting is appearing.
Because He has said that he has served a copy of the counter affidavit.
Yes, my lords, we have received it, but we are ready to argue the matter today
Okay.
itself.
Today itself, or he wanted some other day to be fixed?
My lords, we can, sir has seen the counter and we are ready with the matter. Because we need urgent interim order today.
Ready with the matter?
Some other day it is possible.
Day after tomorrow?
Yes.
That will suffice?
My lords, I'll just check. Mr. Singh was there only, he's probably just on the washroom maybe, and he's just coming, my lord. For the date, my lords, I.
Just wait, let us call the matter serially, then we'll go on. Three has been done. Oh, third matter, okay, sorry.
This is the three item that matter, where there is a, apart from the online EMD, RTGS petition.
Oh, that's the physical.
The petitioner submitted online bank guarantee, and same department was accepted the.
Oh, that's the discretion that you said, discrimination has been done.
Discrimination has been done, and
Some of the persons who have been shown qualified,
Yes.
actually they have also submitted
Same
the
department.
online bank guarantee.
Yes, sir.
What is your instruction?
Let, you kindly turn to page 29, the petition is premature.
Why?
Millard, at page 29.
You have placed them as disqualified, then what premature?
Millard, that is a provision.
You may be not, you have not immediately opened the financial bid. Let us understand, but that does not mean if you are disqualified and he raises an issue that the person whom you have qualified have also committed the same mistake which you are pointing to him. Then
Millard,
he has an opportunity to be considered at the time of financial bid.
Millard, at page 29, Millard, clause 8.6.1 of the DPCL, Millard, there is a provision.
What provision?
If he is aggrieved, he has to file a representation before the technical committee, Millard. He has not done that, Millard.
For meeting the just a formality.
No, Millard, it's not a formality.
Have you ever taken a decision, conscious decision, reverting your own decision? I have not come across a single instance till now.
Millard, I am coming to that. That's it, kindly turn.
My question to you is very simple. Have you qualified a person who has also submitted an online bank guarantee?
Millard, in respect to this tender, we have not qualified. Millard.
Can you come on affidavit?
Yes, Millard. Millard, I have filed affidavit. Today, I have the instruction, Millard. We'll
Show us.
Not this tender, but same department,
No.
other tender work. Yes, I have been copy last supplied.
That is, Millard, in respect to that tender, that tender
This-
inviting committee was different, Millard.
No, the clause has been interpreted in the same way.
No, it's a different tender. Now, this tender inviting committee, they have taken a conscious decision, Millard. That's it, kindly see, Millard.
Sir.
One of the bidder, Millard, its name is Sri Infra. It was also rejected. Annexer 1, Millard, he submitted a grievance before the tender grievance committee. And committee has taken a conscious decision. Let's kindly have a glance to page 11 of that compilation. Page 11.
Yes.
Let's see. Two bidders were disqualified. The present petitioner and Sri Infra, Millard. Sri Infra approves. And decision was taken.
So two bidders you disqualified on
Yes.
this ground,
On this,
online.
yes,
Item, serial number one.
One and
serial
21.
number 21.
21.
With respect to this
This-
particular
yes.
advertisement.
Yes. Okay.
The lordship, the clause also here is the clause that specifically in the tender notice provides that the regarding earnest money dealt by the some circular, and the said circular provides a background. Your lordship, page 18 of the petition.
That circular is misinterpreted.
But you are incorporated.
TK. That circular was issued at the time of COVID and it was in operation up to 31st December 2021. That circular itself says.
Your lordship, that circular is annexure, which is
Yes.
part of the tender notice. Is your lordship kindly 155, your lordship. Yes, your lordship, this said circular was introduced in the part of bid document, and since circular was your lordship, kindly see. This said circular is born from the 171 general financial rules.
But it was operative up to a particular period of time. So by virtue of the expiration of the period, it lapses. You can't take advantage. The circular says that it is operative till such and such.
Milord, the circular was passed on the basis of general financial
Sir,
rules.
if
The
a
general-
particular notification has a shelf life and if it perishes, can you say that it should be applied universally?
Milord, my humble submission to your lordship, this circular was going from the your lordship, see circular on the basis of 171 of general financial rules. The general finance still in force for acceptance of bank guarantee. Your lordship, that is my humble submission.
Nothing.
That's Milord.
They can put a conditions, they can put a restrictions, there is no difficulty.
But say page 33, Milord, there is a specific condition. The bidder shall make electronic payment using his or internet banking. That is the part of
Serial Milord, rule 70, your lordship, page 42.
Page
170, your lordship, bid security. Bid security, rule 177, your lordship. 170, your lordship, rule 170, page 42. And this was a reference of the said circular, which is not altered, Milord, and still
No, it has a shelf life.
is the rule 170.
In respect of this particular tender, this need a conscious decision is taken, and serial number 1 and serial number 21, they are treated at par. And what it means?
Milord, your lordship, then this circular, even if your lordship, Milord, why I am submitting your lordship, this circular was admittedly for the published 2019 for COVID, but it was part of the tender condition, Milord. Even if consciously, Milord, your lordship, clause 18, clause 13, your lordship, they have referred this in the tender consciously, Lord. Even if it's not referred,
That is mere omission or mere mistake that has been done. That does not mean that they have expanded the life.
and
When the tender was floated, after that expiration of the period.
Milord, the tender was floated, Milord, on 25th September 2025.
So
It was part of
much after, and this is mere
the clause 13.
error. This is mere error. They can't apply because it is no longer existing at that point of time.
You can interpret paragraph 4 and 5 read together. These instructions shall be deemed to be part of the PWD code and rules made thereunder.
And your lord,
Fine,
yes, sir.
but that is restricted up to 31/12/2021.
Yes, your lord.
Thereafter.
Yes, but it
So-
is the part.
So OPWD code will prevail over any circle. Right?
Yes. But since they have borrowed from the general financial rule, which is prepared under Article 177 binding on the authority, Milord. That's OGFR rule still in the field. Milord.
Sir, you participated with your open mind
Yes, Lord.
straight away.
Yes,
Now you are saying that you are going, that these conditions are bad, these conditions are not good. Can it be done after your participation?
Milord, my humble submission.
Sir, you are going at the very root that imposition of these conditions are contrary to this particular financial rules. Why you participated?
There is, Milord, my humble
You can't choose. You have to choose one line.
Milord, my humble submission.
Sorry.
I am within the Milord. And
No.
recently, Milord.
We were impressed by your submission when you say discrimination.
Yes, they
And
have done, Milord, they have accepted your
discrimination, no, they say nothing. In this tender, they have this.
No, tender, Milord.
Then if a mistake is committed by some authorities, that does not mean that mistake has to be committed for all time to come. No,
Your Lordship,
it's a high time where.
in January, they accepted
What is
the
this?
e-bank guarantee guideline, Your Lordship, state also.
That's all.
So now the government also introduces circular for e-bank guarantee, Your Lordship. Same watch department. There is changing position, my Lord.
That is after the tender.
Yes, Your Lordship.
So-
The circular was COVID period, and there is, my Lord, COVID circular in the part of the tender notice 2025. And but they have now e-bank guarantee they introduced, my Lord. So just, my Lord, this 27th January.
My lord have decided for similar receipt adjustment.
Mr. Info project.
I'm sorry.
That is the acceptance of, that is clause, Your Lordship, 8.1 decided. That is the one that clause provides acceptance of, after acceptance of tender, Your Lord. Clause 8.1, Your Lordship. I have last time, sir. Paragraph 8.1. It's applied last time, sir. Paragraph 8.
Yes, that's it. Let's go through it. Yes, see. Like, ascertain a date for orders.
Okay. Then to 9th of the. Has to be possible.
Can change. Also, notice under section 140, not in a faceless manner. Notice of under section 140. Item 7.
Item 7, this is challenge to the order wherein the department has not been given effect to the order passed by the CIT appeals. So in one of the sister concerns of the petitioner company, and Lordship in the last week has passed an order wherein they have been given an opportunity to take necessary steps and grant the refund along with interest.
So it is the same case.
Same case, a sister concern of that.
I'll take instruction in this matter. We have already received some instruction, but I am not satisfied with the instruction. I'll take instruction.
1 week to take further instructions. 1 week. In all the matters.
All the.
Lordship,
Yes, 1 week next.
And
Item
you
30 is
also perused, you also perused that. Order.
item 30 is also same.
Check up.
8,
74 P.
at Jones and both the matters.
Nine, may I please, Your Lordship? On behalf of Mr. Khandelwal, Your Lordship, I need 1 week time to take further instructions in the matter. It's a fresh matter.
Next week, prayer.
1 week after, Your Lordship, if it is possible.
Custody, does not have custody. Let's say just October of a call because
Oh,
we've done. Okay, Lordship, kindly see notes, kindly turn to the notes, page 75. I've given my ITC reconciliation summary minutes. All that I want, my lord, is all these information are there in the portal. Let the officer, my lord, apply his money, go through all these ITC reversal statements and pass it on them. The Lordship would kindly turn to it.
yes, what?
Your Lordship, so far as the original order is concerned, Your Lordship, after that he has filed one rectification application. Your Lordship, the rectification order is at page 90. Your Lordship, admittedly, Your Lordship may not record my concession, but so far as the rectification order seems to be unreasonable, not reasonable.
It is already recorded.
That I can do bona fide, Your Lordship.
Yes, sir.
So let the 161 may be restored, maybe set aside it to the assessing officer. But
We'll
do the
verify.
needful. Your
Verify documents produced.
Your Lordship, but do the needful, because from the record I have verified, he has filed the reconciliation statement, everything, but since it has been reconciled and reversed, so it might be a error apparent on the face of record. So it can be rectified. Your Lordship, may only 161 can be set aside.
Page 75 and 76 is the ITC reconciliation.
I can read
No,
that.
that's true. That is what he.
Reconsider.
Only 161
We will
because
reconsider on that basis in a rectification.
Along with your records.
Documents and the portal.
Records, portal.
the original order, since it is barred, Your Lordship.
Oh, understand.
And Annex 9 has to go.
Yes, rectification order.
Okay.
Oh, Which, huh?
Your Lordship, without touching into the merit of the.
No.
Your Lordship, that.
Reconciliation is at
75.
Page
75.
75, Annexure 8. I'm grateful to my learned friend, sir.
Yes.
I always said.
We appreciate his endeavor to
Yes.
examine and. Yes, sir.
Yes.
My lord, item 12, this is a state matter, but however, central GST has been made a party.
Next week, let's say I have sought for some instruction, yet to receive it. Next week.
You have not received the instruction.
Clarification to wait from my client. I can see.
Clarification or instruction is required.
That instruction. Instructions. Next week.
He is not understanding.
Understood. Instructions, material instructions. Lacking. Some.
Yes.
Next week.
No option on our. That of the.
Adjourn to 12th February.
That's nothing. So, rephrase my argument, lords. Brought your lordship's attention to page 35 and another 3 minutes. So the entire period of assessment, the person who's suffering a lot from disease known as right side reticulopathy. In my limited search, lord, it's a nervous disease where it's a nervous disease, lord, that nerve, that exit point is pinched. So there's a, it affects my movements, it affects my work, lord. And this is, my lord, from an ortho specialist of a divisional hospital from Kalche. The authenticity, in my humble submission, may not be doubted. And the entire assessment, my lord, was between period of 8/7/2025 to 17/9. And 29/9 was the last, and it got concluded, my lord, on the 1st. So for the entire period, my lord, I was not sick, unable to move out. Even though, my lord, on one particular date, my lord, due to my instruction, I had filed on the last date for an adjournment. But unfortunately, the entire records were not collated. I could not produce it. The entire issue, my lord, is unexplained investment, and by issuing notices to various vendors of mine, because he says the allegation is I purchased 5 vehicles amounting to some amount of money. I have not explained, amounting to 2 crores amount. 5 vehicles were produced, earth movers and other vehicles, and it was unexplained investment. For your lordship's prima facie appreciation, lord, I have annexed all the loan documents, and if your lordship would, and these hypothecations, my lord, have also been endorsed in my RC. I've given the sale invoices from section Annexure 6 series, beginning from page 70, and the RC, my lord, of all the 5 vehicles at page 71, 73, 74, 76, and 78. It all shows the hypothecation belongs that. For your lordship's kind perusal, note, if your lordship would kindly turn to page 71, one of the vehicles. The lordship would see, at the left-hand column, HP details. The lordship would, not very legible. It comes after the vehicle status. The lordship would, fitness, vehicle norm, vehicle status, then comes the HP details. It's hypothecated to the Bank of India. And this is, my lord, endorsed in my vehicle particulars of the RC. And all the 5 vehicles, my lord, have annexed it along with the invoices. I have also annexed, my lord, my bank statements of my loans disbursed right from page 79 to, my lord's page 84, my lords. They're all my bank details, my lord, where I've availed the loan, I've purchased it. So also, my lord, this cannot be, my lord, a unexplained investment under section 69, and a huge demand of 2 crores or more is there, only because of an ex parte order where I have a cause, my lord, for not being able to attend. So all that I pray, my lord, one opportunity.
You could have gone to the appellate forum.
Your lordship, very correct. I have
So
I have an appeal remedy, but your lordship
Yes.
would appreciate an individual who has
there is no outer cap there.
No, there's no outer cap there. Your lordship is correct. There's no outer. It is the business system. There's no outer cap. I can have reasons to explain. But your lordship, this ex parte order, my lord, is because of a nervous illness which was not under my control. And I was under treatment, and I'm still.
When you filed on the last occasion an adjournment,
No,
did you disclose that?
My lord, unfortunately, my lord, I just prayed for time, hoping that I'll be, Lord, bounce back to health, my lord, so that I'll be able to attend.
Did you disclose the ground
No,
of
of course
this
not.
illness?
No, my lord, it was not.
Why?
It was just time. Because your lordship knows, he, my lord, is an individual.
Adjournment petition must have been filed by somebody else, expert.
No, not an expert.
No?
He is one of the employees of the person. Electronically, he has filed. He's not an expert and he's not a consultant. And prima facie, my lord, I beseech your lordship that your lordship would be satisfied that these cannot be termed as an unexplained investment and addition to made on the system. So one opportunity, my lord, let him go through the papers and then pass orders. Now a penalty proceeding has been initiated. 2 crores or more, my lord, for an individual small contractor, my lord, who has just begun, my lord, his works by availing bank loans from two lords to finance.
So it is in the nature of a mercy petition.
It's a nature. I said, my lord, I preface, my lord, my argument that it's a mercy petition.
Limitation period is?
The limitation is 30 days.
No. It's assessment.
Assessment, my lord, it is
assessment year 24, 25.
24, 25.
Current.
It's not that it will be barred by limitation. The lordship will set back now one opportunity. And I hope my learned friend will be fair enough, my lord, at least.
It's an appealable order. But in the court.
I asked this question and he has admitted. If there is no outer cap, then where is the difficulty?
One opportunity, let him go through my papers. There can't be unexplained investment under section 69. Any day, your lordship's fix, my lord, I'll appear, or my consultant would appear and produce those documents.
No, it is a faceless one.
So no, I can, my lord, I can upload all these things. The assessment, my lord, in a faceless manner can also be uploaded. These documents can be uploaded. Because of this lack of uploading or my inability to upload all these documents, I am now faced with all these problems.
Ignorance of law is not.
No. I won't plead. No, I never, my lord. That's why, my lord, the only term I can use, my lord, mercy, which falls from the heaven like a gentle drops, my lord. And definitely it will fall from my lordship. One opportunity, my lord, before, my lord, condemning him to a demand of 2 crores or more.
Yes, the documents are galore that he has obtained a loan. All these vehicles which he purchased, there is a source of money provided to him on account of a loan.
I think a lot of opportunity was given to him, but
that he says, and he has submitted a document which says that if it is a neuro problem, then in that event the movement is very much restricted. I understand that particular document, but after all,
It is not time bar. It's not time bar. You have sufficient time also. One opportunity to verify the document and pass separately. No adjournments shall be granted.
Yes.
Ed Jones and I.
Wait, please, your lordship. My lord, I was assessed for the period 2023 and 2024. I went in appeal and my appeal was rejected on the ground of delay. However, my lords, I fall into 1074. There was a delay of 8 days. And my lord, they have specifically rejected where I had produced a medical document.
Where is that? It was within a condonable period.
Period, my lords.
Where is that?
174.
That covered order is there.
Fourth one.
Fourth month, my lord. Under similar circumstances.
Oh, where is the order?
My lord, the order is that the appeal order is at Annexure 6.
Six. Page.
At page 27.
No reason is provided.
No, lordship. Delay in submission of appeal in April 2.
But he has filed an application for condonation.
No application. Previous page 26, lordship, there was a show cause. He has not replied to that show cause notice, lordship. Page 26 is the show cause notice.
I had uploaded the condonation petition during my filing of appeal.
All the evidence
is at Annexure.
Let him submit.
All the requisites.
Yes, lordship. Let him produce that evidences.
Previously, your lordship have passed one order. Let him produce all the evidences before the appellate authority, and appellate authority considers.
My lord,
Condone the deal.
in consultation with my learned.
Yeah,
Yes, lordship, I will.
Yes.
Grateful, my lord. Item 16, my lord. Item 16, 14 to 73. Item 17.
74.
Item 18.
May I please, my lords? It is little matter. Your lordship, lords.
So you have suffered a crushing from them. Being involved in crushing.
Accident. Happened accident.
Crosser business. Crosser business.
It's a reciprocal one. File no. There is a file.
This matter, in fact, needs to be tagged along with one pending matter in the case of this petition of yours.
The body language and the facial expression of your formidable opponent shows that he has a very strong point to reject.
Here, absolutely, your lordship will find this matter to be totally incorrect. Totally, this is incorrect. This matter, I think, oh, you have been. So let him know the case first. He must have gone through in detail. I understand he is a very good counsel. But let him know. I think he must not have gone in detail so far as the earlier petition. This was so what has happened in this case, Vilas? My payment, what I have made, Vilas, that was not considered for which, Vilas, I approached your lordship, Vilas, against the show cause notice earlier. Your lordship said that why I approached your lordship knows, Vilas, the litigation policy and the scheme of law concerns, so far GST is concerned. If someone pays the money which is quantified within 30 days from the date of show cause notice, Vilas, or even quantification of liability, Vilas, then the proceeding abates with payment, everything stands concluded. That is benefit in to do away with unnecessary frivolous proceedings, continuing proceedings. So here what has happened?
there is a notice for 5 periods accumulate. I am not on the other clubbing issue. That is also substantive issue. That's in granting interim order in all matters. I am on that, but I am not at the right domain. I am not. Because here, even though the notice is for 18, 19, 20, 23, what has happened? For 3 of the periods, I have paid money, they have not accounted for in this focus notice. But had it been accounted for, I could have an opportunity to pay the rest and come for get the benefit of. But your lordship directed that I have filed rectification application. Your lordship taking note of directed, you dispose of the rectification application. And if you find that this is to be done, then you have to proceed with the so-called notice which you have issued. Further, what they did, because even though section 161 mandates an order to be passed in DRC 08 in respect of a rectification application, they did not comply to that. They reduced the payment which I have made to the department, they reduced. But instead of acting upon your lordship direction pursuant to the so-called notice already issued, they issued a fresh so-called notice, DRC master. Once they issued fresh DRC 1 I challenge before your lordship that has become barred by limitation. Because section 74 2 says that the notice is to be issued at least 6 months prior to the date of limitation expired. Because here that has had they complied with my direction, probably limitations would not have arisen. So they on their own risk, they did that, and I challenge for lordship. That writ is pending for lordship in WPC number 3675825.
What is this order?
So now what has happened? Because when the matter is pending, instead of I informed them that I have challenged the notice against before your lordship, that is pending there. And in spite of my intimation, because on 18/12, because I made intimation appearing for them. They instead of waiting, on the very next day they passed the order, and that is under subject challenge for lordship. So unless that is decided, this cannot. So only now for the moment, your lordship may kindly call the other connected matter, which is the genesis, all that flows from this 36758 of 25. Let that come tagged up, both of them this flow.
Next week, tag with this submits that the interrelated matter being WP
Was the diary, but now, yes,
is pending before this court.
So may I pray in the meantime, let them not take in coercive action. At least till 12, I will.
In your lordship, RC cancellation and condemnation of delay matter, notice copy already served with the State GST Council.
What?
RC cancellation.
Yes, sir.
Yes.
Rule 23.
Item 20. Item 20 is regarding non-constitutional GST.
He has already took it. But the latest one, yes, we have already.
Yes.
Should be.
This one.
Item 21, you're not sure. It's to section 73 4B of the Finance Act.
Saturday.
Jones Saturday.
So item 22 minutes. The petition for lordship grants, as my lords knows earlier, your lordship have also directed and state appeal over there. It is for the NJS exemption under 1026 AAB. Pending appeal, I have moved an application for interim direction not to recover 220 subsection 6. Now, despite of my lord's earlier order, and also CIT appeal, which was in my file, so this honorable bench has passed on order that I am entitled to exemption. Because now in the meantime, they have already given a letter. My friend will.
They have already given a
They are
full
not going to
stay.
recover this money till this one appeal. In view of your I take note of, and not saying no further order will be necessary in view of this clause. Till this one, this is very clear also. Till this one appeal, no recovery clause. Initial direction was 20% recovery clause.
The appeal is pending.
Appeal is pending now. I got to kindly take note of this, their communication. Assessment order is annexure 3 minutes. Appeal I have filed for
And
form
then
30.
page.
Page minutes 26. Assessment order.
D'accord. The petitioner
Item 23, Your Lordship, may I please? 23 and 24 is RC cancellation matter, Your Lordship.
Also
24.
23,
23 and 24, Your Lordship.
correct?
Yes, ma'am.
Yes.
Okay.
Here I have made this payment. Excess payment. For which I applied for the
Refund.
The double payment has been made by mistake, sir. So for that reason, refund, we have paid it. So first I paid it, thereafter I paid that, claim the refund after the proceedings of 74 has been completed. So it was within the particular time. Well, actually, they admitted that there is a double payment and they have taken it in a wrong provision, saying that it will be from the date of deposition. But
What?
the amount which you have,
Which you deposited, yes, that will be taken from the date of deposit means?
so from the date of the limitation, they have deducted that on the basis of the limitation, they have.
Refund application is barred by limitation.
Say that. That is was that the refund application is filed beyond the period of limitation.
My lord, here they actually got my case is will fall within the Act 54D and HF. In that, so from the date of the order passed. It will be there.
So limitation has to be computed from the date of the order, not from the date of making the payment. Which provision?
Now there are two ways. I'm submitting that. If this section 54, it says it starts with the May. That is, it is a 2 years is only when a directory, not a mandatory. Even if that 2 years is taken by the explanation, the relevant date. This are lastly, they have invoked it in another case, the date of payment of tax. So this is a residuary entry. My case, the with 15.4 falls within D and F. That page 9 of the read petition.
Section 54.
The page 9 of the read petition.
I'm asking. Section 54. Subsection.
Subsection 2, that relevant date when that provides with the given at last please.
That is the 2 years before the expiry of 2 years from the relevant date in such form and manner as may be prescribed.
54(1) says that if the tax has been paid in an amount or any amount, may make an application before expiry of 2 years.
So
from the relevant date.
Correct.
May, this is one.
May means what? That's the option is given to you that you can make an application.
That is a
You may choose not to make an application as well. So
then what will be the relevant date?
That's true.
That relevant date has been given to that is last.
The explanation.
In the explanation.
Explanation to? No.
54 in.
Where is the explanation?
That after 2 to 11.
Yes, explanation which you are referring to, I think is relevant to
Specified.
subsection 14.
No, even subsection
For
10.
the purpose of this section.
Specified date means the date of filing.
That is different, sir. That
Yes.
is in relation to
Relevant
subsection
date.
10.
Okay, yes. Relevant date is subsection 14.
No, that is also not correct. That is
referable to 5 and 6.
It starts with that for this purpose of this section, this is the explanation for the whole to that purpose.
Yes.
Explanation. Explanation two. Two.
Explanation?
With the explanation, my lord.
Uh,
One is refund and two is relevant date.
no, I understand.
Then
A, you are referring, B, you are referring, which one is you are referring?
I am referring to F.
F.
D also.
And a D. D and D first. In case where the tax becomes refundable as a consequence of a judgment.
Oh, is there any order, judgment or a decree that is passed by the appellate authority or court or anything has
Communication with judgment, degree or order.
from that date?
From that date.
So is it a case factually? Was there any order
Yes, my.
for refund?
No, refund order is after I have paid it, the proceedings have been dropped by an order of 74. That is annexure 4.
Yes.
And that F is there.
Annexure 4, page
38.
Yes. The date of the judgment is
Case 37, it has been dropped. The proceeding was dropped on 8/11/2024.
Annexure 4.
it was 8/11/2024.
Case 37.
Yes.
Sorry.
Yes, 8/11.
Annexure 3.
Correct. Page 37.
Case 30.
Correct. Digitally signed is on 8/11/2024. That means that's the date of the order.
That is the order. They have dropped it. And
Yes.
the entire order sheet I will also annexed there.
Then when you make an application,
After that, I have made an application. Refund application on 23/8/2025.
20,
25 million. 23/8/2025.
where is that? Page?
Page 40 to 50 million.
Huh?
Page 40 million.
40.
40.
Yes.
This is the refund application which has been filed.
Yes. So,
And
this was you have filed DRC 3 on 8/2. No, it can't be.
Refund application another 5 million, that is 40 to 50.
What is the date of the application?
Date of the application is 23/8/2025.
No, I do not find. Where do I get it, this date? Where do I get it? Show me. Show me the date, sir.
Yes.
There is 25 application. I do not find. Where is the application? 2025? Which is referring? So where is that application?
This way.
That last page has not been, page 41, after 41, there must be that 42, at page 42, that should have been the last part of the application is not available. Because the application start at page 40.
Page?
RFD1, page 40. The refund application.
Sir, page 50.
50.
Page 50. Date of application is 23/8/2025.
Oh, yeah.
देखो ना दिखा जाने चलता
Yes, 23/8/2025, second column. And the order was November 2024. So
That is not applicable. That subclause, that is not applicable. Your Lordship may again go.
what?
Your Lordship, that D, clause D is not applicable. Clause H
Maybe.
is applicable. Clause H is applicable. Not D is applicable. Your Lordship may kindly go.
He has done export.
Your Lordship? No, that explanation. So far as the explanation is concerned.
The explanation is relative to 14 only.
No,
Not 14.
Not 14. Your Lordship.
This section, entire section.
Intersection.
Otherwise, he would have, it
Your
would have
Lordship.
said subsection for this subsection.
But 15 has come.
Yeah.
Huh.
15 is inserted. That is.
Subclass D, Your Lordship, department has lost one case, Your Lordship, already, so far as the VAT is concerned.
Yes,
Your Lordship, may kindly
consider
tell,
this.
in case where the tax become refundable as a consequence of judgment, decree, order, or direction of the appellate authority.
Not the assessing authority.
Exactly, it is not basing here what the provision says.
No, you are taking cue from that.
Now, Your
saying
Lordship.
that appellate authority has not passed, the tribunal has not passed.
That is one
court
part.
has not passed.
One part. The second part is this refund has not been flown from the order itself. Your Lordship, two parts. For that reason, the subclause H is
As a
applicable.
consequence. If consequence is that it is dropped and you are admitting that there is double taxation, how can you retain under Article 265?
That's what I have to take instruction.
No,
What take instruction?
Sir,
I was, prima facie means what?
As per the
Sir,
provision.
you admitted that he has made an excess payment of tax. Can you charge any excess payment of tax?
No, not at all.
Can you retain any excess amount of tax without any authority having granted under the Constitution?
That's the provision.
So
That's the provision.
the provision has to be read, has to be harmonized so that at least the SSC is not harassed.
Your Lordship, at any time anybody.
Perhaps you are not read Mafatlal in proper perspective.
Your Lordship, on the enrichment, Your Lordship.
No, I am not
Lordship,
on, I am not on unjust enrichment. I am on the aspect of Article 265. Whether double taxation you can retain that amount.
Your Lordship, so
Can you retain?
Let me take instruction on this issue. Whether it is admitted, whether that amount is there or not. Your Lordship,
So we will interpret that provision of the appellate authority or a court or a tribunal. We will do it.
So it is an human error. It is an human error. He has paid twice and you admitted twice. So one set you have to return. That's all.
Your Lordship, I'm not disputing Your Lordship. But so far as the provisions are concerned, Your Lordship, Your Lordship, because this D is not applicable. This H is, the D may not be applicable. This H is applicable from the date of tax. Your Lordship, I'm not going to all the, so far as the technicalities.
Perhaps, Paradip, we have delivered a judgment. Paradip Phosphates. Interest we have awarded.
Yeah.
Yes. That was only on interest and refund.
Yes.
Mr. Sahu was appearing.
Your Lordship.
We have delivered one judgment. Refund you have admitted, ocean freight, you do not have it will not come within the purview of GST at all. So Article 265 will attract. Section 54 has no application. This is what the perspective of that judgment is. I think.
Your Lordship, let me take instruction. It is a case of refund. Let me take instruction and take counter.
That's to have in the rejection order.
How much is the amount?
If they get 12 lakhs amount.
Since when you have paid? 2022 or 21-22?
DRCC, he has, DRC 3 years. annexed.
Secondly, they have again issued a notice by mistake on that basis we have submitted it. The cost it was paid. Then after it was, this is the, by mistake it had done. So it comes within the.
Refund करिए तो दे ही दियो तो.
तो जबरदस्त नहीं, we have not taken forcibly from them.
No.
Your lordship, your lordship held.
Sir, it
Application
is not
is
required. It is not required. In case any amount flows to you without authority of law, you have to return.
without authority of law.
Yes.
It is not
You
without
can't be
authority of
retained,
law.
sir.
Why not?
We have
There are many
after
things to argue.
Your lordship, after
Many things to argue when you talk about it.
lordship, after instruction I learned.
Instruction and to दे ही दियो तो आगे तब instruction.
Next
Otherwise,
your lordship, that power is only with your lordship.
No.
Because
Not
we
at all,
cannot
not
bring
at
the
all.
statutory
Not
authority,
at all.
cannot go beyond the statute.
your commissioner and all other authorities are bound by constitution. They are not above.
Your lordship, I bound up. Your lordship, but that statute, because that statute binds us, binds the authority, being the statutory authority. So your lordship can do, your lordship. I'm grateful. The 3 weeks.
Next week.
1 week after.
No, sir. Take instruction. Immediately call.
Your lordship, let me try.
Immediately call.
Let me make this repetition in procures. Let me try to make
No,
it.
it's
1 week
not.
after.
Take next week. Let us see.
10 to 12 separate. Item 26.
Yes, who is for the other side? Yes? Yes.
Your lordship 73 votes. Sub-item 1.
Yes.
Sub-item 2 and.
Yes.
लिखिए दे slip.
There is only one sub-item.
Correction has been.
Who is appearing in the main item?
मुकेश अग्रवाल प्रथम.
Yes. Jones Senate. June Senate.
Another 2.
May I please, Your Lordship? Here, my lord,
Offline or online?
my lord,
Off shop or on shop?
of shop. Annexure 2, page 15. The shop was closed, taking recourse under section 26(1) because some persons alleged that 2 persons died of that locality, taking consumption of the liquor from that shop.
Huh?
Liquor of that particular shop.
What?
2 persons died. The villagers gathered in front of the shop. They alleged those persons have died. They're taking the liquor from this shop. Then the shop was closed. Lordship may see the language, page 15. On order dated 17th June 2025, Article 2, the Superintendent of Excise received information from the inhabitant of Lakhimsagar, Bhubaneswar, that 2 people died consumed spurious liquor brought from the Kalpana IMFL office of Lakhimsagar, Kotak Road, Bhubaneswar. The Superintendent of Excise, Bhubaneswar, and other officers and staff immediately rushed to the spot in presence of the complainant, inspected the shop and checked each bottle. Many people.
No, I say there's nothing could be
Then my lord,
conclusively should come out.
so collector has power to close any shop only for 3 days. When 3 days, he has to obtain prior approval of the commissioner. The next document. Prior approval was accorded by the commissioner for a closure more than 3 days.
Yes.
Then Annexure 3 series, page 17. After getting the report of chemical examination.
Not received at that point of time.
Then after 1 month, almost after 35 days, Lordship, with reference page 17, I'm reading my lord. With reference to subject matter above, I am to inform you that a thorough inquiry has been made by the.
It is said that not due to consumption of the liquor, rather due to the prolonged chronic disease.
Then, my lord, next stage. The inquiry report also I have.
The postmortem must have been done.
Yes, my lord. Everything they have inquired into, they found that those persons who died for their prolonged illness.
Yes.
Page 22, Annex 4. Immediately, shop was open. After 35 days.
Yes.
Then, my lord, I submitted an application.
This was open.
Open, my lord.
Good.
Then, my
22.
lord, Annex 5. I submitted an application for exemption of the statutory fees as well as the MGQ because in view of lordship's judgment that clause was involuntary clause. Because I have an involuntary clause.
Involuntary closure.
As per your lordship's judgment.
Huh.
Then, my lord, application was followed by the superintendent with remarks. The shop was closed for 35 days. The commissioner, my lord, by the Annex 7, they have rejected my application. Lordship sees the provision. Rule 45 of Orissa Excise Rule. Rule 45.
Yes.
Lordship, the closure of liquor shops. First 1, 2, 3, 4, my lord. These are the date for mentioned for closure. That is, my lord, one of these is 26th January and other dates. Next, lordship, we come to clause 5. No compensation shall be payable for closure of licensed premises during such days. Then, my lord, provided that in case of closure of premises of any licensed vendor under 620 exceeding 3 days, a compensation proportionate to the monthly license fee along with the proportional minimum guaranteed quantity may be reduced as compensation to the licensee. Next, provided further, the commissioner shall have the power to withhold or reject the claim of compensation if he has reason to believe that the compensation is claimed on fictitious or frivolous grounds. So, Lord, they have closed. The allegations found false after due inquiry. So, I have made an application for exemption of that particular 35 days. Because the shop was closed at the instance of the state government. There is no fault. A false allegation was made. Subsequently, it's found the persons those who had taken liquor, they have not tied out of that spurious
No,
liquor.
that's right. Yes, what do you say about the applicability of this provision? Discretionary on what ground? On 2 grounds. It only says is fictitious or frivolous grounds. The exemption, if it is on a frivolous or fictitious ground, fictitious means there is no semblance of there is no truthfulness in the incident. And frivolous is that the compensation is sought on a ground which is absolutely not true. There are documents which shows that yes, there was an order imposed upon him by the collector to close. Then there was a permission sought for extending. It is also there. He could not operate. Then ultimately the stock was checked. Samples were drawn, sent to the lab to have the report whether it is spurious or not. Report that does not reveal. Even a postmortem which was done of those deceased person who claimed to have died because of this consumption of the spurious liquor. The report does not say that it is because of that. It says it's a chronic disease he was suffering earlier. Shop has been opened. What more? Is it a frivolous or a fictitious ground? Fictitious may be an imaginary.
The shop was closed as a preventive measure so as to avoid any law and order.
Tell me that what power has been given to you that you can take this ground? What power has been given to you? If the rejection is controlled only on 2 circumstances, can you bring a third circumstances being a statutory authority? What is the law on the subject?
I would request kindly grant me 1 week's time.
Open is a very open and shut case. Does not require any other consideration. A right is conferred. He has asserted that right. Yes, definitely a discretion is with you, but it should be exercised on a parameter. Simply you say as a preventive measure. But at least one thing is apparent, that he was prevented from selling. Is it not?
Because of the problem.
Show us that the preventive measure does not come under the purview of this.
To that extent, I will.
There is no provision.
Proviso.
No, proviso is very clear.
Very clear. Proviso to this
It's very clear.
26-1.
Hmm?
No, 26-1. And
26-1 also says by
3 days.
Uh,
3 days.
3 days.
Beyond
And beyond
They
that,
have not served a prior notice also. 26-1 clear source.
It no-
Prior notice is required. That has not
Well, it's a
applied.
copy, if annexure 50, if page 15 may kindly be seen, then here it said copy to Sri Ayush Saku. So he was informed about
Subsequent
closure of the
closure.
shop.
Subsequent closure.
And since the situation was so.
no, I understand the situation was so grave that administrative decision is to be taken. You have applied 26, not 26. 26 is suspension.
26 the closure of
Closure
within
of
3 days by the collector.
But 26,
Section 26.
oh, section.
Section 26.
Oh, sorry. They also
Is it,
section.
so he has
Power to
invoked
close
also
temporarily.
26-1 in at page 15.
Page 15.
Page 15, you have invoked 26-1.
Uh-huh.
So 26-1 proviso. You see proviso, the reverse page. 26-1 proviso.
This is what your letter also speaks of, is a public peace.
Yes.
So you have invoked 26-1. Then approval of the excise commissioner, that was also taken by you. And then this proviso says where it was provided exceeding a compensation proportionate to the monthly license fee along with the proportionate minimum guaranteed quantity may be reduced.
He's praying for total exemption, my lord. So reduction may be allowed.
No, that will be reduced. That is the you have to adjust that particular amount for 35 days and the MGQ also. He has prayed for exemption.
Yes, madam. Annexure 5, page 23.
This proposal was not.
For the closure period, he has asked for a closure period. He does not ask absolutely.
Therefore, the amount can be adjusted and accordingly.
What? Reduced means you'll have to make it lower, on a lower side. If he has to live 200, then he'll have to say for this period I have reducing it for 180. It is one of the
restrict for the flow of refund to the SSC, flow of refund to the SSC. And according to our, we have to file a counter affidavit on this regard. But I have the statement with us that refund has been flowed to them. In the meantime, he'll may verify the things, and in the meantime, we'll file the counter affidavit in sworn in affidavit. Document I am producing that we have already flowed the refund for the years. Let him verify with his record.
So it has already been.
There are, look, let me verify this record with my statements, whatever they have given, then accordingly we can. Ascertain them. The only point which your office will correct, the only point which was left to be decided, left for them to answer was whether the interest calculation and the refund already issued, which is undisputed, was till date or till the refund order was passed, giving effect order was passed. That was the only point which was not yet clarified by them. So based on this,
You verify?
yes,
You
today I
verify
have got this. I'll verify how much they refunded based on what figures.
So Lordship, all the adjustment was made in 9, 10 and 10, 11. Adjustment was made in assessment year 11, 12 and 12, 13. And according to the refund was issued on 2025 also. And recently today also on 21/1/2026, we have passed an order and it has been signed by the DCC at today itself for the assessment 11, 12, a refund of 149, some odd amount will be also refunded to.
So that,
Let him
that is the
verify.
latest development.
Let him verify and
Verify and pass it on. 1 week, next week. In both the cases.
All right. Item 31. Also, item 31 papers of time.
Well,
the Lordship, Mr. Kirut Sahu, who is appearing in this case, yesterday his missus has been expired.
Oh,
So,
how much? 3 weeks?
26th February. Item 32.
last occasion in item number 32, we have already passed the rectification order, Your Lordship. From interest to tax to interest now.
My Dhanit Senior was showing me the order earlier, Your Lordship. I'm yet to receive a copy of the order.
That has been
What I find-
uploaded.
No,
That is
I've
uploaded.
cross-checked, Your Lordship, it's yet to be uploaded. Your Lordship, one thing, as I find from the order is rectified. Here in the DRC 7, which is infused for Your Lordship, there is no problem. In the detailed annexure, there it says that it is the demand of interest. In the DRC 7, the summary of the order.
IGST and interest.
Interest is shown in the integrated tax column. As a result of which I'm facing the problem, Your Lordship. And mere correction of this, rectification of this won't help me because I have before Your Lordship against the appellate order. So appellate order APL 04 also reflects that same amount. For which I cannot again file a second appeal before the tribunal because again it will ask me for a further 10%. So unless those are taken care of, Your Lordship, I don't think it's a solution.
Appellate authority, let him rectify. Appellate authority.
CPA filed before.
So that she can move the second appellate tribunal.
We have already passed the Lordship that order, and regarding DRC 07, we have I have to take instruction the necessary correction to be done. We have issued a ticket with the
Now, on the basis of DRC 07, which you have rectified, can she file the second appeal without depositing any conditional
it's
amount?
online. If she verified and see that if it is showing, not showing, it will be taken off.
Then again, it has to come back.
I'll be guiding up the Lordship.
What will
By filing an online application,
you will say that is automated, that is not accepted.
Maybe it may be automated.
You are acting
because the
mechanically.
Order has been passed, so definitely it might be uploaded, and a necessary correction may be made
So when the order is passed?
on 28/1/2026.
28/1.
Yes.
Till date, you have not uploaded. She said that she has cross-checked. It has not been uploaded. So
Again, I'll be verifying that DRC 07. We have issue.
we are keeping this matter on a day after tomorrow. You just verify it. If you can't, then this matter is.
Today you try to upload. She will try to file second appeal. In the meantime, if it's done, it's all right. Otherwise, first appellate authority has to do. Has to take
I'm
it.
forwarding the.
Yes, please.
Yes.
Return to fourth February.
On the tax bench.
Yes.
Thursday, 5th.
Every day is very good for you, the tax bench. Why you are putting a spanner into it? Let it come.
Return to fourth February. Item 38. For item 33, that matter of change of status bills. As my lord, 72 PAN card issued in the 1972. I have requested for change of status, because then I was requested by the ITO Bureau to make online application. So one, before I advance argued with the Lordship Bureaus, the other day, so my Lordship kindly remember, I have brought to Lordship's attention page 22, there is a drop down, page 22, Annex 7. It's a mistaken instruction Bureaus. The drop down result is this Bureau. So only they say that the proof of identity doesn't match with the proof as per document. That has nothing to do with the change of status. Somehow, this is the outcome of that. Your Lordship said, if I click, what will come? This has come. So this has nothing to change of status, but somehow, I think my.
Then from where you got this document?
But in the meantime, they have.
At page 22, from where you got this document?
Mirrors. After clicking mirrors, this appears.
No, this document which you are annexing.
Mirrors. This 1, 2, 3 mirrors.
Whatever.
22, page 22.
Page
Annex 7.
This yes.
It appears to be a completely different document from where your client got this.
Also, after clicking on this occasion, we have written, please click here for details. That is the details paper. Last occasion, they told that this.
They were saying that this clicking will show this 1, 2, 3.
Yes.
No.
But it does not. It does not appear that 1, 2, 3. We had a doubt. That's why we raised.
Have the doubt, yes, the other day. Not to have the doubt. I remember.
Because the moment you click any icon there, it takes you a separate page.
This has come, but this has nothing to do with the content.
So I was very much apprehensive that what you say is correct. Your junior was so vociferous, overconfident that he says, no, this comes. On the same page, very difficult to come.
So now they have come up with a solution.
Your Lordship, we had a solution. We have a
solution.
We have given after getting instruction from the
So
system, they have to do.
Now it is infructuous.
No. But that solution, unless you clarify, may not help us. Now what they say that you surrender the old PAN, we will the ITO will delete it because, and after deletion you apply afresh for a fresh PAN number because. Requesting change of status that because once a PAN exists with us, no fresh PAN because of section 139 can be issued with us.
True.
He said you surrender that. And after I surrender, you have to make a fresh application for PAN mirror with the change status which I now require to have it mirrors. So that will be issued mirrors. Now the only question is mirrors. So for the intragnum, the date of surrender and the date of issue of the change of status mirrors. Unless I am protected by Lordship's clarificatory observation, because it impacts my eligibility to have exemption. And because I will also take leave of my lords with a few lines that you presented to all bank, all other authorities, whatever it is required for correction of record. So these two things have to be taken note of. With this matter can Because this has to be made again online, 49A.
You are so dependent on computer environment.
This has come only because of lordship intervention the other day. Otherwise, I don't think till now.
Depending on a mindless mechanism or machine. Without having any discretion to apply.
We don't have any role that
You don't have.
When the system of who are giving PAN, they have the allotment not with the IPO.
Then why to appoint so many officers?
It's a
Only machines would do.
separate system.
We can also do here.
The system they are allotting the PAN allotment through NSDL. They apply the PAN through NSDL or UTI.
That high flown words will be beneficial for your officers, not you.
Two things, that I read for these are not inevitable for my house.
This is one of the example. There was another example in the other court where on a single applications, 2 PAN cards of a same person with different numbers came. Now he was skeptical that what should I quote for the purpose of uploading the item?
Correct. Bound to happen.
Which one is genuine and which one is not genuine, because both are genuine.
And they say before deleting, it is to mark as duplicate PAN. I also
That is what is the difficult. How can it be a duplicate?
Cannot be. So what I little understood,
In that situations, cannot be said to be a duplicate.
First he'll apply for the new PAN with a specification and after getting that PAN, he may apply for the deletion of that PAN.
What?
No.
How can it be?
139A7.
It will have a larger impact on him. It will be a unjust enrichment. I'm not using the word cascading effect on him.
Lordship, when the PAN is issued, the 4th number, if it is an individual, it shows at P. If it is a HUF, it shows as H. If it is a farm, it shows as F. If the status is changed, that status will be changed from R to some government, that one. If that's unless that status he applied.
It is your internal affair.
Yeah.
You have to take a decision internally. The person cannot be left in you are making your object is hassle free, but you are making it all mess, troublesome.
I think Mr. Kadia's instruction otherwise. What the officer has mentioned.
I think all the computer or all the technologies are subservient to a human brain. You have committed a blunder, you have to rectify. Why they will suffer?
The correction of PAN, let him apply the PAN with this application will be uploaded. Is our this
Everywhere your name is
I'll be verified.
Everywhere your name is written correctly, or ABH or AVI. You must be facing trouble or problems in every field, isn't it? I too, my name is not uttered correctly.
I also joined.
We have to wear having the same.
So far as her name is concerned.
If you are having the same PAN, then unless until the court will
One of my lawyer friend, he has applied for PAN in the name for his wife, and his wife's photograph
Then both, second is there. Sub item one is it is challenge the section 34 and the statutory benefit under section 50. That is cover item only.
This item is 36439.
Yes, yes.
You are challenging an order passed under section 74.
74.
So,
On basis of board instruction. In absence of any for separation.
that is true. You say that ought to have been under 73.
Yes, sir. Matter may be remanded for reapplication.
To let them find their counter evidence.
Yes.
2 weeks.
Yes.
If the one 3 weeks. First item. First item.
That to 16289. That limitation may be taken on 19th February.
Separate order on the prayer, 19th February.
First item is adjourned to 19th February, second item adjourned to 26th February. Item 35 to.
I think 30 maybe 2 weeks after my. 2 weeks after my. 35. Petition wants to end the senior counsel.
Item to 26th February. Item 36. Wait. Because, my lordship, kindly remember the last occasion. I have brought to your lordship's notice the judgment of this honorable court, where your lordship have directed us in view of the notification which is there by the department, directing that servant credit bills, even if that's a dispute for the purpose of limited purpose of SBI, that will be allowed adjustment on Section 124(2). That is one. Secondly, your lordship's further direction was in the view of the fact that because there is nothing on record, so far the claimed amount of payment of 20 crores is concerned, in lieu of that they have allowed 20 crores. So therefore, your lordship said that that is to be verified and accordingly not flow. Now, what has done, Vilas? Instead of Vilas complying to that, your lordship will find. I am taking my lord's attention, Vilas, to 6.1. Two issues are there. One is Vilas, basically, so far as eligibility concerned, that's not an issue. Only the question is, out of 50%, how much I have paid Vilas? So far as 168 concerned, I am protected. That is the order judgment of this honorable court Vilas. Your lordship have seen the other day, against which department has gone to the SLP, but there is no stay of the judgment. That says that relying upon the circular of the CBI bills, that says that 1 crore 68 bills, which is these are all servant credit bills, even if that is a dispute, but for the purpose of because the amount is paid bills, so for the limited purpose SBLDR bills, I am entitled to adjustment bills. That money is to be adjusted against the tax payable bills. Now, second is 26 crores, which I have paid, they have verified, and there is RTI report. In the RTI enclosed report, where the payments which I have made, where I have not only by RTI report, initially also when SB LDRS 2 was issued, after my application under the scheme bills, an opportunity of hearing was granted, as your lordship knows, after 2B, the formalities, I appeared, I have given all details of payment, those are there bills, and without passing anything else, at that stage, what happens? In SBI 2, when any payment is claimed to have been made, and they, after verification, find that it is more or less, they have issued a statement. In the statement, they can, because here now I am saying, they are always now claiming now 926. 926 is not 50% amount. Even if I have mentioned that I have paid more, but actually 50% 8 crores amount. Now I say, after deducting, adjusting 1 crore 68, and this differential amount of 6 crores, about 6 crores, where the balance comes to 60 lakhs, which I am agreeable to pay bills. Had that been intimated to me at the stage of SBI 2 bills, while issuing SBI 3, I could have made payment and matter of component. And without doing that, now you said the 100% are liable to pay, even they didn't consider their own circular. They did not consider the RTI report, which claims verification of bills, all the details of each allowed payment. These are all each allowance, not that bills payment are by any other board. Now I will take my lord's attention to paragraph 6.1 of these are one improved order mirrors. Page 166 mirrors. 166 mirrors. This starts from caption verification of payment made through challenge claimed to have been paid by the applicant. A letter by number so and so dated 25/6/2020 was issued to jurisdiction officer to verify and report the veracity of the declaration made under SBLDRS 1 dated 24/12/2019 bearing ARN number so and so 4846. In reply, the jurisdiction officer by letter number so and so dated 29/6/20 internally reported that based on the affidavit dated so and so made by the applicant and photocopies of challenge produced by the applicant, total service tax paid in cash during the financial 2013-14 is 26 crores 05 lakhs 13,839. But the jurisdiction could not find a report any payment document through a declared pre-deposit 9 crore 96,76,534. This I have not, I have already said I am not claiming this. I am only claiming 50%, not beyond that. Now, your Lordship may kindly see this 26 crores payment, the evidence which I have given your Lordship will find before the designated authority concerned. That is 130. It starts from 131 minutes. I lost my kindly see page 131. RTI information details minutes. Page 131. Only two small paragraphs I'm placing. 131. Whereas you have requested, the caption is information sought on RTI relating to, please refer to RTI application. Yes, you have requested on the RTI that challenge payment made for financial 2013-14. That this is a year your speech concerned here now. Reconciled with range superintendent and range superintendent submitted to designated committee through letter stating the particulars of payment. In this connection, it is to state that report in respect of ARN number so and so, there are two ARN numbers. Your Lordship is concerned with ARN number 84846. The second one of Sabka Vishwas Legacy Dispute Scheme 2019 of Orissa State was sent to designated committee SBLS 19 Orissa from this office on 26/6/20 as verified by the superintendent GST Cuttack 6 range Cuttack with available records enclosed 18 pages for reference. Now we'll also kindly turn to next page, page 132. Page 32, my Lordship will find subject report in respect of ARN, the second one, 4846. Sabka Vishwas so and so of Orissa State. Please refer to headquarter office letter number so and so dated 25/6/20 on the above subject as directed. The desired report as verified by the superintendent GST CX Cuttack 6 range Cuttack with the available record is forwarded herewith for your kind perusal, please. Now, my Lordship will find where the total, it starts from page 134, my Lordship kindly see for a while. And the last 2013-14 is there in the last table. Your Lordship will find final 2013-14. Now, said to have paid in cash 26 crores so and so. Said to have paid to Senbad credit 19 crore 81 lakhs. Total 45 crores 86 lakhs so and so. And each challenge numbers are there from 135 to 137, and total amount your Lordship will find at the bottom of page 137. Mentioned 26 crores 05 lakhs 13,839. My friend the other day submitted for Lordship that this has already been taken care of in the show cause notice. So therefore nothing more is left to be considered now. I will take my Lord's attention to the show cause notice itself. That is at page 54 minutes. Page 54, your Lordship will find these are their own revelations. After verification, they have prepared one table B and table C. My Lordship will kindly turn to table C mirrors at the bottom mirrors. Your Lordship will find taxable value, tax paid and tax payable during 2013-14, which is taken care of in the show cause notice mirrors. My Lordship will find there are two columns, periods, April 13 to September 13, and the second half yearly is October 13 to March 14. Now, my Lordship will kindly see there are service tax paid. There are three columns: cash, Senbad credit, and total amount paid. I think your Lordship can find it. Yes. Now, under the cash column, my Lordship will kindly see there are two figures mentioned. First half period, 6 crore 56 lakhs 84,111, and the second half yearly figure shows 13 crore 69 lakhs 45,281. Even the totaling figure is not mentioned here, but I have added this is.
That is the differential tax payable.
Yes, Mirrors. Yes, ma'am. The Mirrors, this is the cash which I have paid for 2013.
Then the segment credit which you take, and the total payment was added to 14 something.
Yes.
And then the differential tax payable is 13 something.
That is, yes, that is what I'm saying. Just you know, can you bear with for a moment? I am explaining this. The total cash which I paid, according to the table C of the SOCOS, is 20 crores 26 lakhs 29,392. This I am reading amalgam total submission figure of these two figures. 20 crore 26. My lord, kindly bear in mind. Senvat credit.
That is in table B.
Table C, Miller. I am a table C. Table C.
Totaling has not been
Given there.
Cash.
That is why when you are saying
I understand. Your lordship will not get there. I know, Miller. That your lordship will not get.
It will come to 20
Yes, exactly. That is what. Just your lordship will get. It comes to 20 crore somehow. 20 crore 20 lakh. Similarly, Senvat credit, we have 7 crore 73. And 12 crore 7,000. And 19 crore 80. There is no dispute on this. On Senvat credit, there is no dispute on this. The total paid figure is 40 crores. It comes to 40 crore 07. But my humble sum, your lordship, is this 20 crore 26 which they have taken so far as cash payment is concerned in the STN, this amount to 26 crores, which the RTI verification report which I read for lordship, that reveals. And they have also, in paragraph 6.1 of the order which they have passed, they have also mentioned that, admitted that. Paragraph 6.1, that my lords will find from page 166 of the order bills, including lordship bills. Page 166 bills. This bears a caption bills in the column serial number 6, verification of payment made through channels claimed to have been paid by the applicant. A letter white number so-and-so dated 25/6/20 was issued.
No, that you have already read.
Yes, that I have already read. And this confirms my payment of 26 crores.
True. But it says that, but the jurisdiction of office could not find a report. Any payment document through which the payment of declared to be deposited has been given.
This has no relevance because 9 crore, I am also not claiming.
That is my case.
I am not claiming. No, I am not claiming. What I am claiming is only 8 crores. When out of 16 crores, some odd, 50% liability, 8 crores. So even if I have said I have paid more, but now I resign from my word saying that it is 8 crores. Not now, Millers. This resolution was there since 2000 SBL 2 where it was issued pursuant to application. I have given Millers along with all details of payment. What they could have done, they could have said in the SBL 3 which was included for lordship Millers in WPC 25292 that you pay the balance. They did not do that.
Now that the feminist scheme has gone, or
No, that is gone. But still, Millers, so far as the procedure is concerned, your lordship in very many cases directed, even our court also, Millers, that manually you can process the application for balance payment. This can be done, Millers. That's the only point. Because so far as the Senvat case is concerned, I don't think my friend has any case because that's a common.
No, I have a case. I have a case. I can differentiate that judgment also.
My submission is that I don't say I will not quarrel on that. But certainly it's that is judgment, and my lords have, after seeing the judgment, have said either we have the option of a report will observe, otherwise it's binding on the coordinated judgment, and the matter is now before the Supreme Court. They have gone there. There is no stay of my lord's judgment. That is what. That is why you stand. I think.
Yes, my lord, but I have one submission.
That you can get just for the timing period. So that is what I stand below. So far as the Senvat case is concerned. Now, so far as cash payment is concerned, apparently if you admit this is 26 crores, not 26 crores, and if you adjust below 8 lakh crores, 50% liability which I am supposed to pay, and you adjust below 6 crore plus 1.68, and you ask me to pay the balance of 6 lakhs, that would have ended. What more I want? I don't say 9 crore 62. That may be, and that is on a different calculation which I don't now stick to that. I have already in my revised claim I have given in the personal hearing, and also from time to time I am appearing and saying this. I am not on that. So you calculate and you pay me, and I am ready to pay the amount 6 lakhs for some amount. So that is what only it's a matter of adjustment. But so big a case, but it's simply question revolves around, and the question he has issued, the officer has issued two issues in the order itself. Of course, framing of issue is also doesn't have 168 belows. He has framed 2 issues below. My lords will find at page 168 the main issues that need to be examined by me are as below. One is whether OSL has already paid service tax of 9 crore 90. Again, same amount he is sticking to, which is neither payable under law, nor I am required to adduce evidence of 9 crore 96. I am required to pay evidence of 50%, which they have declared as pre-deposit is billed 1, dated so and so, or any service tax in cash to challan against SCN dated 23/4/2015.
Yes, my lord, I will file. It will. One thing I want to clarify. Yes, I'll.
Whatever instruction you have,
I pray for Miner's interim director because they are going to now go for adjudication. That will go to state bill. Further proceedings.
Lord, may I mention one matter
This Thursday.
online?
Lordship items.
I beg your pardon, Your Lordship. Item 70, Your Lordship.
73.
70, Your Lordship. Can it be taken on 9th, Your Lordship?
My Lord, may I mention, my Lord, an IA that we have filed a clarification, my Lord, your Lordship's judgment.
Item 40 will be taken up tomorrow.
Submission thereafter. Thereafter, you will not make any submission, no. It will be listed online.
My Lordship, item 73, interim order. 40 should be taken up tomorrow. I hope I have communicated. Withdrawal of the petition. Grateful.
Lordship, item 62. My assistant mentioned take up the last case of the day. No, only a prayer, Lordship. Can it be any day?
May I mention, my Lord?
Only remand to be made, Lordship. Only remand, nothing, Lordship, to adjudicate. Only remand. Very urgency there, Lordship.
My Lord, may I mention online? My Lord, may I mention online?
Interim orders were there, was that 41.
My Lord, one fresh application I have filed, my Lord, a clarification application, my Lord.
Mention tomorrow.
Item 41, interim orders.
I'll mention tomorrow 10:30, my Lord. Oh, bless.